My lord, in regard to one MSc appeal, my lord, can you lordship allow us to move it on Friday? On 20th of this
Listing,
month.
listing you have to mention before the one more court is taking same roster.
Yes,
Senior court you have to mention.
all right. Obliged.
Right. In relation to item number 43 of my lord, supply list, my lord, Mr. C. Goswami, Learned Counsel, he informed me that he is not well, my lord. So matter may not be taken up today, my lord. He has taken consent from the other side also,
Your
as
Lordship-
intimated.
Your Lordship, this matter may be taken up on Monday
43.
because it's a 43.
He is not well, so let at least 10 days time may be given. Since he is not well, my lord, even my lord, if it is listed on Monday.
1
if
week
he-
thing.
It's a 2000 matter.
Yes. 2000, it is 2020 meter 43.
9 we have obtained degree, Your Honor.
Okay. Heard Mr. What is
M.
it?
Kishore, my lord.
MP
For Steve
Sharma,
Goswami.
Learned Counsel, appearing for Mr. C. Goswami, who prays for an adjournment on the ground that the conducting counsel, Mr. C. Goswami, is indisposed. On the other hand, Miss, what is your name?
Kedas.
K. Das, Learned Counsel for respondent number 1, submits that this is an old pending matter and therefore long date should not be given. Considering the submissions made by Learned Counsel for the parties, the prayer is allowed. Let this matter be listed again on 30 September. On Monday it is 30.
How like
Made physical lordship. Lordship, one item, supplementary item number 39, my lord. It is listed under to be spoken to column. Can it be taken up tomorrow, my lord? And then its senior representing respondent is also there present.
Who is for respondent?
am for the respondent.
So there's
Where?
some difficulty on my part, my lord.
To be spoken to?
Yes, my lord.
No. You submit I am not asking for any submission. I want a written gist of arguments, brief 1-page gist of argument, which you can submit in the next week. I'm fixing a date.
Definitely.
In fact, today my friend has a difficulty. His words admission is there. That is
No,
why he was-
I'm giving a order just
Fine.
now.
My lord.
In item number 39, heard Mr. D. Dekar, Learned Counsel.
MH
for-
Chaudhary, my lord.
Heard Mr. M. A. Chaudhary, Learned Counsel for the appellant. Also heard Mr. A. Dhar, Learned Counsel for the respondent. The counsel for both the sides are requested to submit a written, brief written gist of argument, their respective argument on the next date fixed. Let this matter be listed again on 20. When can you give?
Lordship.
27.
Well,
27
Yes, ma'am.
27 September.
No.
obliged.
Lordship, but that has to be submitted through affidavit or my lord. we
No,
can-
no, you just submit to the court master.
No.
No affidavit.
Deeply obliged. my lord.
Yeah, please, Your Lordship, I beg to mention item 29. It was wrongly listed in the orders column. It was supposed to be listed in admission column, Lordship. The other parties also there.
Item 29. Then we'll take it up in admission column.
Admission.
Yeah. Next,
Both sides are there.
yes, Lordship.
What do you want now?
Date may be fixed, my. Next week, any date.
Okay. Heard Miss Tinlung,
Yes, Lordship.
Learned Counsel for the petitioner. Also heard Mr. N. Hawk,
Yes, ma'am.
Learned Counsel for the respondent. The Learned Counsel for the party submits that this matter has been wrongly listed in orders column, whereas it should have been listed in the admission column. Stop considering the submissions made by Learned Counsel. let this matter be listed in the admission column in the next week on a date to be fixed by registry.
Date will fix, maybe fix, my lord, next week, any date.
On 3rd of October,
My lord,
on
Interim may continue, lordship.
3rd October, interim
Ah.
order shall continue till next day.
Obliged, lordship.
So with the consent of the other side, item number 44. Let's say here in this matter, we have received the copies yesterday late evening by 7:30, 7:30 PM. So kindly give us some time or 2 weeks time to go through the same.
I'm appealing for the appellant in this case, lordship. They have filed execution case and that is fixed on 21st. So, we have some urgency.
So
If it may be taken up day after tomorrow, then we have no.
Lordship, we have received the copies yesterday by late 7:30 PM.
No, this is coming up for
For
admission.
admission column, and their presence is
So
not
we,
necessary in this case.
Lordship, we need some certain time, but date may be fixed. By 3rd of October, it can be fixed.
When is the execution?
On 21st.
For what it is fixed?
They have filed a petition for seizing our bank account. We have filed our objection and that is. fixed
There
for
will be hearing also.
Yes, lordship.
So we can fix it in the first week of October.
First week of October, 3rd of October, because
3rd of-
we need some.
My objection to this prayer may be.
Lordship, we have received the copies yesterday by late evening.
Whatever, but unless there is.
No,
some-
but you have received the copies.
Yesterday, we have
They have
received, at the
received
same
for
time, we need some
petition of
time to
appeal.
go through the same.
Their presence is not necessary, even it is. not
So,
necessary to be
Lordship,
heard.
time be granted at the same time, 3rd of October, date will be fixed.
This is first appeal only. We'll take it up when the matter is called.
Lordship,
We'll take it. You are praying, you are objecting only to interim prayer.
Lordship,
He has an IA also.
I'm praying for certain time be granted. At the same time, a date may be fixed.
Okay, heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr.
S. A. Bhakhtiar,
S. A. Bhakhtiar, learned counsel for appearing for
respondent
respondent,
number 1,
respondent number 1, who prays for
2 weeks
some
time.
accommodation on the ground that he has received the copy of memo of appeal yesterday only. Stop considering this. On the other hand, learned counsel for the appellant has submitted that the respondent has already initiated execution proceeding and therefore there is an urgency in this matter and prays for listing the matter at the earliest. Considering the submissions made by learned counsel for the parties, the prayer is allowed. Let this matter be listed again on 1st of October,
Lordship, first I shall not be available.
3rd of October will be.
3rd of October,
Yes.
3rd of October.
Outlines.
May I please lordship. Subsequent matter, my lord, subsequent application, my lord. And already, my lord. 430 days, my lord. And 40, my lord. Witnesses have been enlisted in the charge sheet, my lord. And 7 vital witnesses already have been examined. So at this stage, my lord, short date may be given, notice may be issued, my lord. Hope so, my lord.
Okay. Heard
As is ship.
Mr. S. H. Sigdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Stop. This is an application under section 483 of BNSS filed by the petitioner Rafiqul Islam, who has been detained behind the bars since 4/7/2023. Stop. Since this case involves an offense under POCSO Act, let the notices be issued to the notice be issued to respondent number 2. Stop. The petitioner shall take steps for issuance of notice on respondent number 2 as per the prevailing notification in this regard. Stop. let also the scan copy, let also a status report of the special case number 180/2023 be called for from the Court of Learned Special Judge Boxer Dhubri. And also the scan copy of the case record be also be requisition. Registry to take step for requisitioning the scan copies. Let this matter be listed again on 4th of October 2008.
Fine.
May I please, Your Lordship? Lordship, before submitting, Your Lordship, I would like to draw your attention that one typographical error has been made, Your Lordship, in page 2. Instead of Nagaon, it should be Jorhat district. So I may be allowed to correct it, Your Lordship. And on the last page, Your Lordship, that prayer portion, Your Lordship, page 8, during pendency at the last prayer, Your Lordship, it should be Principal Judge Family Code 3.
You submit, you correct, amend it as per the prevailing notification.
Yes, sir, I would, Your Lordship,
You-
but before that, Your Lordship, I would like to submit it, Your Lordship, as a stay is necessary in this case.
No,
Your Lordship.
unless you make corrections.
Only that two portion, Your Lordship, rest petition
No,
is,
You correct it immediately within a day or two. We will take it up.
yes, Your Lordship, within a day I will correct it, Your Lordship.
Third
The
miss
matter may be posted, Your Lordship, for tomorrow or Friday, Your Lordship,
Friday.
Friday.
Heard Ms. P. Das Lanin, legal aid counsel for the petitioner, who submits that certain typographical errors have crept in the petition filed by the petitioner, which needs to be rectified. And she seeks leave of this court to file amended petition, corrected petition. Stop, the prayer is allowed, the petitioner is allowed to rectify the errors and file the amended pleadings as per the notification number 79 dated 19 June 2023 issued by registry in this regard. Let this matter be listed again on 20,
Friday.
yes,
Friday,
20,
Your Lordship, Friday, there would be difficult, Your Lordship, as Your Lordship, other matter has already been fixed, Your Lordship. Then, Your Lordship, Thursday, Your Lordship,
tomorrow.
tomorrow. So it won't
Let
take
this
much
case be
time.
listed again on 19/9/2020.
Deeply obliged. Please, Your Lordship.
Under certain peculiar circumstances, we are seeking to invoke the revisional jurisdiction of the Honorable High Court as against the orders passed by the Learned Trial Court dismissing a suit. In fact, Lordship, just briefly, I'll place the facts. What has happened, the petitioner as plaintiff had filed a suit under the Specific Relief Act for cancellation of a sale lead. For non-filing of the evidence in affidavit in time, the suit was dismissed. That was by order dated 4/9/2019. Thereafter, the petitioner was also confused as regarding what remedy he has. Obviously, the remedy would have been to file an appeal under Section 96. But and in the meantime, the COVID came, and after the COVID, post-COVID, he filed an application under Order 9, Rule 9 for restoration of the suit. Admittedly, there was an error. It was not a correct exercise of remedy by the, but the learned court below, what he did was entertain that application, and as it is, there was a delay in filing that application under Order 9, Rule 9 for for restoration of the suit. On the grounds of a delay, the suit was the application under Order 9, Rule 9 was dismissed. As against both the orders, now as against that order,
Which order? Second order.
Yes, the second order, both the orders we have come. As against the second order under order 9, rule 9, if an application is dismissed as against
it-
it,
that
appeal
was
lies under
not-
order 43.
First it was,
10/8/23. He preferred the
which one? First order was on 4/9/19.
4/9/2019
That was dismissed for failing to adduce evidence.
evidence. Now, the dismissal was under order 17, rule 2. Admittedly, if you pay.
Appeal lies.
Appeal will, because it was not a dismiss for default. If your lordship kind
No,
of.
therefore, order 9 application does not lie.
Does not lie, but
Yes.
the petitioner, under a wrong belief of on the wrong appreciation of the legal provisions, he filed an application under order 9, rule 9. And that too in the year 2023 by with a delay of around more than a year. Because the COVID, under the COVID, there, as per law laid down by the Honorable Apex Court, there was a certain period which was needed, which required to be waived off. Considering that aspect, probably it would have been 1 year of delay. But by order dated 10/8/2023, the application under order 9, rule 9 was dismissed on the grounds of delay. With the observation that no sufficient cause was made out, but it was a wrong entertainment that could not have been entertained. There was what we are on is that the learned court below had acted with material irregularity in entertaining that application. That should.
Who was the petitioner? You were the petitioner.
I am the petitioner plaintiff. Petitioner plaintiff.
No, you do not seem to have any case.
If your lordship kindly peruses the original order, out of which the entire proceedings lie
Because-
at page 31. 4/9/2019. CPC order 17 to 4/9/2019. May I just read out just a short
Page?
order? Page 31.
Yes.
Parties are represented. Today was fixed for evidence of the plaintiff side. Today again, the plaintiff side has paid for adjournment on the ground that the plaintiff is unable to appear due to his sudden illness. No medical certificate accompanies the petition. Already the plaintiff side has taken several dates for filing evidence for the plaintiff side. Hence petition number so-and-so stands rejected. Order 17, rule 3 CPC provides, court may proceed notwithstanding either party fails to produce evidence. Now, provision reads, where any party to a suit to whom time has been granted fails to produce his evidence or to cause the attendance of his witnesses or to perform any other act necessary to the further progress of the suit for which time has been allowed, the court may, notwithstanding such default, if the parties are present, proceed to decide the suit forthwith, or B, if the parties or any of them is absent, proceed under rule 2. Now, had the suit been dismissed under order 17, rule 3B, then probably an application under order 9, rule 9 would have lied. But here, as it is, the parties are present. So we will be covered by order 17, rule 3A. If the parties are present, proceed to decide the suit forthwith. So the suit is dismissed. It has to be presumed that the suit has been dismissed on merit because the parties are present. It cannot be said to be an order dismissing the suit for default. So in that circumstances, an application under order 9, rule 9 will not lie.
Okay. But you were the applicant.
I am, yes, I am
So
the
it would
applicant.
not
now.
lie.
Yes, we
A
filed,
case
yes,
where an
Yes.
application does not lie,
yes.
assuming that court dismissed it on some other ground. Otherwise, also it would have to be dismissed because by your own submission, the application does not lie.
No, that, yes, jurisdictional error,
Now, what relief you are seeking here?
no, if that application is dismissed, my right to appeal lies. That I have been deprived of.
Now, how? Your right to appeal lies only against order under against order dated 4/9/2019.
2019.
You have not preferred an appeal.
That
You
is what-
yourself,
No, I acted, yes, obviously, admittedly, the petitioner availed of a wrong remedy. That that ought to have been that, even this is wrong. The learned court below acted with material irregularity. That could not have been entertained on that ground. The order 9 rule 9 application could not have been.
Not for this
entertained.
reason, for other reason, it should have been otherwise also dismissed.
No, Lordship will kindly appreciate this aspect. The order 9 rule application petition was accompanied by an application under Section 5 of the Limitation Act, no doubt, because there was some delay. As regards, had it been had the petitioner plaintiff was correctly advised and would have preferred the correct remedy, he would have preferred an appeal, and under that the limitation is different. And so all in all, the learned court below had wrongly appreciated that petition. That
Where is the impugned order?
impugned order page 39. In page 39, order dated 10/8/2023. Now the learned court below has referred to that delay as 3 years, 104 days. In fact, we have calculated that. It's just more than a year, in fact, after waiving of that COVID period. COVID period given time.
So your submission is that, no, what is your submission?
My submission is that the original proceedings which was dismissed on the ground of default. Obviously, that was dismissed, that cannot be presumed to be an order dismissing the suit for default.
Yes,
That has to be presumed as an order dismissing the suit on merit.
under
As against that order, an appeal lies.
17(3)(a). Order 17, Rule 3A.
Yes. Order 17 rule 3A, that could not have been decided under order 7. The learned court below presumed that it is an proceedings under order 17. It should be proceeded under order 17 rule 3B2. That was what it presumed, and accordingly it was considered to be an order dismissing the suit for default, which could not have been, because the order itself indicates the parties are present there. As such, the order dated 10/8/2023 that could not have been entertained itself by the learned court below.
No, this is again barred by limitation. Your revision petition is.
That would have been entertained by a superior court. The same court is here entertaining that.
No,
we have
but
to-
it is you only who filed that application.
Yes, we filed it on a obviously a wrong legal advice. Even the
No.
petitioner was confused. And if
No,
your
the
lordship-
present revision is also barred by limitation. The present limitation, the present revision is also barred by, is it within
No,
limitation?
it is within limitation. It is within limitation. We had filed it on 10/9/23. There was some defects, later on we came to know, and then we rectified the defects, and as it is.
No, but
10
the seal is
Okay.
13 September 2024.
13/10. 19/10/2023, we preferred it. It was within the limitation period.
Now, what relief you are seeking? Assuming that it is admitted, notices are issued, what relief you will get?
Relief, lordship, if as it is the learned. court
Suppose it,
below had agreed-
assuming that the impugned order is set aside, then your, by your own submission, that case is, that order 9, rule 9 application is not maintainable.
Not maintainable.
Then
my right to appeal gets revived. Right to appeal. And that will be dealt with by a superior court, not by the same court. And considering all these aspects, whatever, we get a chance there. Because the superior court will not only go into the delays, obviously the delay hurdle has to be crossed there also.
okay, heard Miss D. Borgohain, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure read with section 151 of the said code has been filed by the petitioner Shri Kuldeep Singh, impugning the order dated 10/8/2023, as well as previous order which was passed on 4/9/2023. Order dated 10/8/2023 passed by Court of Learned Civil Judge Senior Division, Golaghat, in which case
Ms. J case number 39 of 2022.
in Miss J case number 39/2022. It appears that the seal put on the petition by the filing assistant of this court of the filing section appears to be of 13 September 2024. And if said date is taken into consideration, it appears that the present revision petition is barred by limitation. However, learned counsel for the petitioner submits that the petition was in fact filed on 19/10/2023, which is within the period of limitation. Keeping the point of limitation open, let the notices be issued to the respondent. And let the case record of Miss case number. What is the, which record is to be called for?
Please record, in fact, Lordship, if Ms. J case number 39/22 is called for, along with that, the titles of records will be also done.
Miss
That
J
is a-
case number 39/, you have not mentioned anything in the, your cause title. Miss J case number, tell me the Miss J case number
39 of 2022.
39 of 2022, along with the case record of title suit number
Title suit number 7 of 2017.
7 of 2017 from the Court of Learned Civil Judge Golaghat. The petitioner shall take steps for issuance of notice upon the respondent through registered post with AD, as well as through usual mode within 7 days from the date of this order, returnable after 4 weeks.
Obliged.
Wait a minute. Also, by this revision application calendar of Article 227 of the petitioner is challenging the order dated 28/2024, passed in petition number 3417/23, in title suit number 157 of 2017. By this application, my lord, the plaintiff intends to adduce secondary evidence in respect of a money receipt, which is purportedly executed by the petitioner.
Where is the impugn order?
My lord will find the
Page.
impugn order at page 82. There are two applications were filed, one on the order 11, rule 14, 3416. We are not aggrieved by that portion of the order, my lord. We are aggrieved by the portion relates to petition number 3417. If I may take your honor to the last few lines, your honor, my lord, also seen petition number 3417.
Yes,
If I may read, your honor.
yes.
Also seen the petition number 341723 under section 65 of the Evidence Act, read with section 151 CPC with a prayer to exhibit the copy of money receipt as secondary evidence. In the said written objection, the defendant number stated that the said money receipt is a forged document and as such there is no merit in the petition of the plaintiff. Upon hearing and perusal, it appears that the said money receipt is with respect to the payment of advance consideration in respect of the suit land, which is necessary for the proper adjudication of the matter. Petitioner stated that the said money receipt is misplaced. Considering the above, the instant petition is allowed irrespective of objection by the defendant. Accordingly, petitioner is allowed to exhibit the said money receipt as secondary evidence. Very cryptic order, my lord. My lord, if I
No,
may-
it is clear, it has been reasoned that it has been, money receipt has been misplaced
my lord, if
and
I-
it is necessary.
My lord, if I may take your lordship to the facts of this case, my lord. Here, what had happened, my lord, the defendant number 2, alleged
No,
to-
in revision, we are not going into 227 revision.
My lord, may kindly first take up the application that they have filed for allowing secondary evidence, my lord. At page 64. Sorry, my lord, at page 74.
No, how this order is without jurisdiction or.
My lord, there is no factual foundation regarding the applicability of section 65, my lord. Secondary evidence cannot be adduced in a routine manner, my lord.
No, reason has been mentioned that court has mentioned that the money receipt has been misplaced.
My lord.
That is enough.
My lord, I am just taking to their application, my lord, what they have stated in their application.
Where is that application?
My lord, at page 74. Before then, my lord, from the very beginning, my lord, the summons was served upon the defendant number 1, my lord. It was served.
No, let us not go into other aspects.
My lord, this is a fraudulent document and FIR is pending, my lord, in respect to this particular document, my lord. We
No,
are denying it from the very.
you will get opportunity of cross
My
examining.
lord, cross examination opportunity is there, but my right to send it to the FSL has been curtailed by this order, my lord. They deliberately did not produce it. This money receipt, wherein, my lord, may kindly see the money receipt for a while, my lord, at page 33. My signature and the very next page, that is also my signature in the written statement. My lord, may compare the signatures, my lord. At page 33 is the money receipt, that may my signature.
No, these facts, these issues, a 227 court will not go into these factual
My lord,
aspects.
then their application, my lord.
You
What
you can raise this please before the trial court.
that we
you-
have raised, my lord.
No, you will get a opportunity of cross examining the witness.
My lord, may kindly take up their application at page 74,
Yes,
para 3. That the, if I may read, my lord,
yes.
that the plaintiff has filed a photocopy of money receipt dated 18/11/2024 in the suit during cleaning hours. This is their explanation, my lord. The original money receipt dated 18/11/2014 has been misplaced and in spite best effort, this said document could not be found. No FIR, nothing, my lord. During cleaning hours, where, my lord?
No,
Where-
this is
when,
their
how?
plea that it is misplaced.
Misplaced, my lord. My lord.
Now, whether it has been misplaced or not, during cross examination, you can verify.
My
But
lord,
for
on-
allowing a 65 application, that is enough, that original has been
my,
misplaced.
For my satisfaction, my lord, there is a judgment of this honorable court, my lord, on similar thing, my lord. My lord, may kindly have a look on this. I will take it.
What 65,
65,
what 65 says?
65, my lord. 65, my lord, cases in which secondary evidence relating to documents may be given. We are concerned with section 65C, my lord, it says about, if I may read 65C, my lord.
Evidence. Yes,
When the original has been destroyed or lost, or when the party offering evidence of its contents cannot, for any other reason not arising from his own default and neglect, my lord. There is no explanation as such that there was no default and neglect on his part. The section itself says, my lord.
yes.
My lord, I am once again reading, my lord. When the original has been destroyed or lost, or when the party offering evidence of its contents cannot, for any other reason not arising from his own default or neglect, produce it in a reasonable time.
No, but it is lost. It is or. So if it comes to one or, if it is lost, that is enough.
But not for his own default or neglect.
No,
At least
that's-
something
that-
has to be spelled out in the
No, you
application, my lord.
read it again. It is or lost or party seeking. That is an option,
My lord, kindly-
alternative.
I appreciate one thing, my lord. From the very beginning, our says that this is not my signature and the signature in the LS power of attorney. Because the witnesses, one more aspect, my lord, the witnesses who had allegedly signed this power of attorney, that was my mother. My mother had expired in the year 1998, and they are allegedly saying that.
No, we are not going into
My lord,
fact.
not go into this aspect, my lord, but forgery is apparent, my lord. So this matter may be examined, my lord, at least at this stage, my lord. And somebody will tomorrow and again say, since we are preparing to send it for FSL, so
No,
they are
you,
saying that.
you convince me
My lord,
that
but-
court was wrong.
My lord,
in-
kindly see the judgment of our High Court, my lord, 2015.
What it
CLR,
says,
my lord.
yes.
That Paragraph 10, my lord.
You read it. Which portion you want to rely?
My lord, paragraph 10.
Yes,
Section 65C, my lord, if I may read that.
read.
Section 65C of the Evidence Act has several elements. The first condition is that the original must be destroyed or lost, or that the parties seeking to produce it cannot do so for any other reason which does not arise from his own default or neglect. It is pertinent to note here that the other reason for which a primary document in existence cannot be produced by a party must not arise from his laxity or negligence from the side of the party who would get the benefit if the document is so produced. This is because if a clever party finds that one's original document is produced before the court, then the contesting party would get the chance of cross-examining by pointing out its inherent deficiencies as to execution or otherwise. In such case, he may opt to hide his own documents showing that it was lost or not received. Under such circumstances, he will derive the benefit for his own default, which cannot be the purpose of law in adversarial form of litigation. This is why legislature in his wisdom was cautious in coining the provision. Section 65C therefore deliberately mentioned the reason not arising from default or neglect to produce the document in reasonable time. This is why to get the benefit of Section 65C of the Evidence Act, burden lies heavily on a party to show that the documents have been destroyed or lost or cannot be produced for some or other reason, and such reason does not arise from the default or neglect of the party concerned. Merely showing that the document has been lost or destroyed would not be sufficient for party to get the benefit of Section 65A of the Evidence Act. He is also duty bound to show that non-availability of the document is not due to his default or neglect. This is clearly on the same issue, my lord. My lord may examine at this stage, my lord. Another judgment is your 2011 budget, simply would not be required at this stage. No explanation as such in the application, madam.
Let us read 65. To my understanding, 65C contains two grounds. First ground is when it is lost. Second ground is when the party cannot party for reasons not arising from his own default could not produce it in reasonable time. This is the second ground. So first ground, when it is lost, then the question of own default or neglect does not arise.
My lord,
But we will examine it. You have.
obliged.
When is the date fixed?
Tomorrow,
Tomorrow for what?
tomorrow for laying secondary. evidence.
Heard, Mr. What is your name?
GJ Soikia, madam.
Heard, Mr. G.J. Soikia. This is item number
41, supplement.
G.J. Soikia, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Shankar Ram Barua, impugning the order dated 28/2024, passed by Learned Civil Judge Senior Division number 3 in title suit number 152/2017, whereby the application filed by the respondent under section 65 of the Indian Evidence Act, Evidence Act was allowed, and the plaintiff within bracket slash respondent was allowed to file secondary evidence of the secondary evidence in respect of the photocopy of the money receipt dated 18/11/2014. So Learned Counsel for the petitioner has submitted that while allowing the respondent to file secondary evidence in respect of the money receipt dated 18/11/2014, the trial court did not consider the aspect as to whether the failure on the part of the petition, part of the respondent to produce the original arose out of the default or neglect of the respondent himself, as nothing was mentioned in the impugn order regarding this aspect. Stop. Learned counsel for the petitioner has also submitted that while allowing an application for educing secondary evidence under section 65C of the Evidence Act, this aspect has to be taken into consideration. Stop. In support of his submission, learned counsel for the petitioner has cited a ruling of this court in the case of Chandra Sakhi Singha and another versus Vidyapati Singha, reported in 2015 for GLR 830. Stop. Let the notice be issued to the respondent. The petitioner shall take steps from which court? Guwahati Court.
Guwahati.
Petitioner shall take steps for issuance of notice upon the respondent within 3 days from the date of this order by registered post with AD as well as by usual mode.
I'm praying for stay of the further proceeding.
Stop. Let this case be listed again on October 4th, 2024. Till next returnable date, the operation of impugn order only to the extent of its allowing the deducing of secondary evidence by the respondent shall be kept in abeyance. List accordingly.
Please, your Lord. The petitioner hearing our ballot substituted different number 1A and 1B in the suit that is pending before the learned Civil Judge Senior Division number 3 Kamrup Metro. What happened, my lord?
Which order you are impugning?
My lord, page 57, my lord. Well, actually, on prior to that, may produce
57 order dated?
24/1/2024. What happened, we were actually substituted on 2/3/2022. That is page 53 prior to that, for a time being. And by this order, 2/3/2022, we were substituted in place of this is dependent number 2.
As his legal representative.
Legal representative. May I place one fact, what happened, the respondent number 1 as plaintiff instituted the suit, for a specific purpose of contract, the scheduled land, that belongs to one Dr. Biharilal Chaudhary, it's in Ulubari area, What happened when during his lifetime, he gifted the property to defendant number 2, that is late Minati Chaudhary, who was his wife. And during the subsistence or during what happened, during her lifetime, she executed an agreement with respondent number 1, purportedly, respondent number 1 and defendant number 2 had an agreement for developing the plot of land,
Okay.
And what happened? During lifetime of defendant number 2 and defendant number 1, defendant number 2 again gifted the plot of land to defendant number 1.
Okay.
This is the defendant number 1 being her son, But during COVID days, both of them died. First, defendant number 1 died, that is a son of defendant number 2. Then, within a span of 9 days, she also died.
in 21. Now, my lord, when she died, defendant number 2 died, my lord. Defendant number 1 was unmarried. So being unmarried Hindu, my lord, the property devolved around defendant number 2, being the first class legal heir, my lord, as a mother. Now, after her death, my lord, these one, defendant number 1A, 1B, 1C, being the daughters and sons, they were substituted. So that substitution happened in 2022, my lord, page 53.
Okay.
So, after that, my lord, when substitution happened, my lord, the petitioners engaged their counsel, my lord. And my lord will find, my lord, at page
Now,
50,
who is the petitioner here?
the daughters, my lord. Daughters of defendant number 2.
Daughters of defendant number
2, my lord, 2.
2.
Yes, my lord.
Who is the mother?
Mother.
And daughters were also substituted by order dated 2/3/2022.
Yes, my lord. Yes, along with another son, late Kamekha Chaudhary, who also died, my lord, in 21, 17/9/21. Now, my lord, Kamekha Chaudhary suit got abated against Kamekha Chaudhary because his legal heirs has not been my lord, substituted by the plaintiff, my lord. Anyway, my lord, what happened, my lord? After our engaged counsel, the engaged counsel, but he did not, well, perhaps took safe step, my lord. And accordingly, my lord, the defense could not be filed, my lord, for these substituted defendants. So my contention is that, my lord, when they came to know in 24, my lord, they engaged in a separate new set of counsels, my lord, and they have made submissions before the learned court, my lord, for, my lord, although it is not reflected here in the order, my lord. So I was told, my lord, verbal submission was made for filing the written statement, my lord, and that was
But
rejected.
But there is no such reflection in the
No
impugn
application.
order.
No application. That is fact.
Now, why are you impugning this order?
Because, my lord, kindly see, my lord, in this
Order dated 24/1/2024.
Yes, my lord.
What is your grievance?
Straightway, it is fixed for cross-examination because the plaintiff, PW1, the plaintiff's evidence in chief, my lord, was filed in 13/10/2015 itself, my lord. 13/10/2015, the evidence in chief was filed, my lord. Till late, my lord, he has not appeared for cross-examination, my lord. And only in 2022, we were substituted, my lord. So, my lord, although the earlier counsel, my lord, he made a categorical, my lord, prayer, my lord, for filing WS, but that was also.
Where is that prayer?
Kindly see, my lord, page 56. 12, order dated 12/7/2022.
Yes.
On behalf of newly imputed legal heirs of deceased defendants, Dr. Jolly Chaudhary, and it should be Preeti Chaudhary, my lord, not Kirti. Their engaged counsel has filed a petition bearing number so-and-so, praying for time to file WS, prayer is allowed. Someone issued to Kamekha Chaudhary has returned with report that he has expired on so-and-so, as such plaintiff to take steps for substitution of the legal heirs. So, my lord, prayer was made, my lord, but somehow or other, my lord, it could not be filed. And prior to that, my lord will find, my lord, there is another order that was passed in 15 order to. My lord, the learned court, my lord, taking a hyper-technical view, page 43, my lord, when the defendants were alive, my lord, holding that 90 days period was mandatory, my lord, it was also rejected. The prayer was rejected to file WS. Kindly see, my lord, page 43. There is a type copy, my lord. May I read, my lord? Both sides are represented. Learned
No, but
advocate.
the 43 is an
43, my lord.
order of year 2015.
15, my lord. My lord, why I want to submit, my lord, during the lifetime of the defendants, my lord, their prayer, my lord, to file WS was also rejected. Only holding that 90 days period was mandatory. Whether it is not, my lord, it's a directory procedure, my lord. So, taking a hyper-technical view, my lord, that prayer was also rejected, and the suit proceeded, my lord, without filing the WS, even for the deceased defendants, my lord. So, my lord, being substituted defendants, my lord, we have a right, as per Order 22, Rule 4, my lord, to file our defense as in our legal character. My lord, there is another issue, my lord. Since, my lord, they are now legal heirs of defendant number 2, this is defendant number 2. they may have a separate defense for their own. For the, in that region, in that case, they may have to be implemented as an independent defendant, not as a substituted defendant. So that issue is also there, So learned court ought to have considered that aspect also, thereby allowing us to file a WS.
No,
And-
but there is no reflection that you prayed for filing WS, whether there was a prayer. That prayer was,
I was told that verbal submission was made for a learned court, but it was not at all entertained,
what is wrong in this order?
wrong,
There is nothing wrong in this order.
we should have been given a chance, to file the WS. And straight away, it isn't fixed for cross-examination of the
When were you substituted? You were substituted in the year 2022.
22, I have made specific pleadings, that we were not aware about the developments of the suit, because
No,
the,
after your substitution,
yes, from page 56, it appears that the council engaged took time, to file WS, but somehow or other it could not be filed. Page 56, Then, the only 2-3 dates were there. In the next date is fixed on 11/8/22, then 3/11/23. On duty till that time, 3/11/23, the defendant number 1C was not even substituted. The substitution process was not completed, So, my humble request, with any condition, a chance may be given to me, to take my defense, as a substituted defendants. And the cross-examination was fixed yesterday, no? And PW1 again remained absent, without any steps. In fact, the apex court has also held in the decision, that just
no, not necessary. You don't have a case. Oh, what is there in this case?
it's only regarding the subsidiary defense. It says, while relying on one judgment of namely Jagdish Chandra
When is the
Chatterjee.
next date fixed?
Next date. 2/11, I'll file my WS with any condition,
No, not without hearing the respondent.
So it says, in the judgment, relying on one Jagdish Chandra Chatterjee, page paragraph 3, the principles, for order 22, rule 4, down below,
How many respondents are there?
Let us say. Four respondents. 3 respondents, sorry.
Heard, Mr. R. Chakraborty, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed, impugning the order dated 24/1/2024, passed by learned civil judge, passed by the Court of Learned Civil Judge number 3, Kamrup Metro, in title suit number 184/2014, whereby the suit, whereby the next date for the in the state suit has been fixed for cross-examination of plaintiff's witnesses without affording any opportunity to the substituted defendants, who are the petitioners in this case, to put their defense. Issue notice to the respondents. Issue notice to the respondents and call for the scan copy of title suit, scan copy of the record of title suit number 184/2014. The petitioner shall take steps for issuance of notice by registered post with heading as well as by usual mode within 3 days from the date of this order, returnable on 23rd October 2024. List this matter accordingly.
This is the interim prayer order.
Your case is in November. We are fixing it in October.
All right.
Yes, Mr. Jha.
May I please, your lordship, on the last occasions, if you were asked to go through the records. My case is herein, your lordship, FIR is at page 70. My case is, your lordship, the contraband item was never recovered from my possessions. The allegation is that the contraband items were recovered from the abandoned vehicles.
From the,
Vehicles which are abandoned. Well,
show me from,
your lordship. Your lordship, page 19. FIR, your lordship.
Mr. Sharma, you have gone through.
My lord, I have gone through some parts, my lord. Some have yet to be gone through, my lord.
Now whether.
My lord, from the vehicle, my lord, Fortuner vehicle, 100 packets of heroin, my lord. It was recovered. And thereafter, my lord, 65 packets of, my lord, heroin from his rented house, my lord. From the present
Rented house
petitioner.
of the petitioner.
My lord, present petitioner, my lord.
Your lordship,
That amounting to, my lord, 765 grams, my lord. And all the witnesses said his
Regarding-
involvement, my lord, he is the prime accused, my lord, in this case, my lord.
regarding this, your lordship, regarding the recovery from my house, your lordships. In fact, it is recovered from the other accused person, your lordships. There is no specification where is my house.
Where
What
is
is
the
the
Caesar
house
list?
number?
Where is the
There is
Caesar
nothing.
list?
My lord, here I have, my lord,
Nothing is there, your
Where
lordship.
is the Caesar list? Page at which? What is your name? The name of.
My
Abdul?
name is Dilbar Khan.
till, my lord. And several Caesar witnesses are there, my lord. In
And
presence of
moreover,
the
your
witness, my lord.
lordship, 50 witnesses. I am already behind the bar for 1 year, almost 3 months.
This is not a case.
My lord.
But your lordships, 50 witnesses.
Maybe.
That is defined, my lord.
Heard Mr. N. Jha.
Your lordships, regarding this Caesar.
No, no, my lord, already
Caesar part.
recovered from my.
Whether it is recovered from my house or what, whether it is particularly, this is my house.
Where is the Caesar list? Have you annexed the Caesar list?
I have not annexed your lordship. On record is there. Your
Uh,
lordship, an allegation is that it is a rented house, your lordship. There must be some specifications. only because alleging that it is my house, I am.
That is his house, my lord, that is from the,
No, no,
this is a witness, my lord.
That it has to be proved from.
It is
the court.
proved in the trial, my lord.
Oh, yeah.
Whether he is. my
Trial
lord,
basis,
house-
you have to.
Heard Mr. N. Jha, learned
My lord.
counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor.
Whether your lordship's a specification of any house and it belong to me is there, your lordship. Only mere allegation, your lordship.
No, trial is on.
Trial is on.
Trial-
Witness has not
Char-
been called for till.
Charges are framed.
Search frame, my lord, search frame only on 3/6, my lord. 3/6/24, my lord.
Your lordships, even if it is 50 witnesses to be examined, your lordship, it will take 10 years, your lordship.
Not at
The
the
way,
moment.
because 3/6 already charge was framed. Today we are in the, your
How-
lordship,
How many witnesses are examined till today?
no witness, your
Not,
lordship.
no witness, my
Not
lord,
a single
only on
witness examined.
charges frame on 3/6, my lord, 3/6/24, my lord.
And now we are in the 18, your lordship, 18/9. No witness, not a single witness turn up, your lordship, and call for by the prosecution.
Only three.
How much time it will take, your lordship? My humble submission, your lordship, directly no contraband item has been recovered from my position. your
No,
lordship.
my lord, some witnesses are there, my lord.
Witness-
Caesar witness, I have played my.
Caesar witness says that it not recovered
Also
from
heard
me.
Mr. B. Sharma,
My
learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Muhammad Dilwar Khan, alias Muhammad Dilbar Khan, who has been detained behind the bars since 25/6/2023, within bracket, for last 1 year, 3 months, more than 1 year, 3 months, bracket close, in connection with NDPS case number 201/2023, pending in the Court of Learned Additional Session Judge number 2, Kamrup Metro at Guwahati. Stop. The gist of accusation in this case is that on the basis of an FIR, where is the FIR?
Here's 19, your lordship.
Huh?
Here's 19. 19.
FIR lodged by one
Vikram Basumtari, your lordship.
Vikram Basumatari, Inspector of Police, before the Vikram Basumatari, Inspector of Police, before the officer in charge of STF Police Station regarding seizure of $785 grams
765.
765 grams of suspected heroin from the rented
lord.
accommodation of the accused persons named in the FIR, including the present petitioner, an investigation was initiated. And on completion of the investigation, charge sheet was laid against the present petitioner and other co-accused persons under section 21 within bracket small c/29/25 of the NDPS Act, 1985. Stop. Next para. Learned counsel for the petitioner has submitted that the petitioner is an innocent person and the contraband was not recovered from his possession. He also submits that the petitioner has been detained behind the bars for last more than 1 year, 3 months. And though the charges were framed on 2024. And more than 50 witnesses are listed in the charge sheet. Not even a single prosecution witness has been examined till date. And therefore he prays for allowing the petitioner to go on bail. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that the contraband involved in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act comes into play. Stop. He also submits that the seizure list clearly shows that the recovery of the contraband was made not only from the vehicle, vehicle, but also from the
Rented house.
rented house where the petitioner was residing. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the scanned copy of the case trial court records, which was requisitioned in connection with this case. On perusal of the seizure list, prepared on 2/7/2023, in this case, it appears that the recovery of the seized contraband was made from the possession also of the present petitioner. It also appears that charges were also framed against the present petitioner on 3/6/2024. And therefore, prima facie, there appears to be materials against the petitioner in this case. And hence the embargo of section 37 appears to be applicable against the petitioner in this case. As regards the submission made by the learned counsel for the petitioner regarding prolonged incarceration is concerned, though there are 50 witnesses listed in the charge sheet by the prosecution side, and though the prosecution is yet to come, though the examination of witnesses is yet to commence. However, this court is of considered opinion that, considering the nature of offense involved in this case, incarceration of 1 year, 3 months may not be considered as long enough to override the embargo of section 37 of the NDPS Act, 1985.
Your Lordships, one submission, Your Lordships, at this stage. The trial court may be directed to, Your Lordship, complete the trial within 6 months, so, Your Lordships.
This
Time may be fixed.
This bail application is therefore rejected at this stage.
Time may be fixed, Your Lordship.
No.
Some time may be fixed, Your Lordship.
No.
Because it is a 50 witnesses and they will go on.
You've
roll
come,
out.
You can approach again and again.
My lord, again and again, my lord. But
There is-
I can, your lordship, but one direction, your lordship, at least sometimes.
No, not at this stage.
50 witness, they have not called any of the witness, your lordship.
Seven.
Item number?
The city was called for, my lord. I on interim bail, my lord. It
My
was-
lord, here I have received the information that charge sheet submitted, my lord.
Josh, you have,
Charge sheet late, my lord.
you have appeared before the
Yes, my lord, I appear.
heard
Well-
Mr. H. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, charge sheet has already been laid, bearing charge sheet number.
95/2024, dated 31/7.
Stop. Learned counsel for the petitioner has submitted that the petitioner was allowed to go on interim bail by this court on 24/7/2024 with certain conditions, and in pursuant to the directions of this court, the petitioner has appeared
Petitioners.
before.
Two
Petitioners have plural, huh? Petitioners have appeared before the investigating officer and have cooperated in the investigation. Stop. Considering the submissions made by learned counsel for the petitioners, that the petitioners are cooperating in the investigation, the interim bail granted to the petitioners by order dated 24/7/2024 is hereby made absolute.
Right.
With condition number 2 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
May I please, your lordship? In this case, I was in interim, my lord, CD was called for.
Have you appeared before the other?
Yes, I have
Appeared, my lord. 8 and 9 are same city, my lord.
Same affair,
Same FIR, my lord.
8 and 9.
Both of them appeared before IO, statement recorded. But IO has collected, during the time of investigation, IO has collected sufficient material against them. my lord.
Against them, but they are cooperating.
My lord, they
Yes,
are
yes.
cooperating, my lord.
In both the cases, there are one petitioners.
My lord,
Think
my lord.
heard Mr.
AK Azad.
A.K. Azad, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the case, who has produced the case diary of
Bongaigaon PS.
Bongaigaon PS case number
196 of
196/2024, and has submitted that the petitioner has appeared before the investigating officer, and his statement has also been recorded by the investigating officer. Stop. It appears that the petitioner was granted interim bail by this court by order dated 12/8/2024. Stop. As the petitioner appears to have complied with the directions of this court and have cooperated in the investigation, the interim bail granted to the petitioner by order dated 12/8/2024 by this court is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of. Send back the case diary.
My lord. Only one line, my lord, may be added, my lord. During investigation, IO has collected sufficient materials, my lord, against him, but he is cooperating.
এক line আগত দিব. Though it appears from the case diary that there are some certain incriminating materials
No.
against the petitioner,
Right.
which has been collected by the investigating officer during investigation, however, as he is cooperating in the investigation, his custodial detention does not appear to be necessary. Stop. Same order
Right.
in
And
item number 9 also.
my lord, condition may be imposed, my lord, that further he will not do such type of activities. my
I have imposed
My
two
lord.
conditions.
That is, they are smugglers, my lord. They are already 2-3 occasions they are involved, my lord.
In item number 9, same order.
Same order.
Name of the petitioner would be.
Monwar Hussain, my lord. Obvious.
Who ordered item 11? Item number 11.
This is transfer petition. Last item is on material.
Item 12.
Mayor, Lordship. Lordship, in this case, my lord, the petitioner here, your Lordship, filed one RSA, that is number 69/2024, and judgment passed on 14/5/2015. But very interesting, prior to pass the judgment, the sole defendant, herein my lord respondent, sole respondent died on 7/10/2011. And the counsel for this sole respondent, Mr. A.K. Ali and Hamidur Rahman, was quite found silent when died. No application was before. So far, my lord, provision order 22, rule 4, when abated against the defendant, the legal representative to file application to brought on record. That has not been done. Now, my lord, when I preferred one review petition, that is, my lord, review petition preferred, that is,
Now, what for this
I'm
interlocutory?
coming to my lordship. I review file, it is a miss case number 56, and that has been withdrawn when come to know that defendant, sole respondent already demised prior to past judgment. So ultimately, that second appeal already been abated. And that is, my lord, order with liberty, this withdrawn, my lord. That is, my lord, page 16 in my condonation petition 4252. When come to know that they filed objection affidavit in opposition, and come to know on record that on 7/10/2011, the sole respondent demise when they filed affidavit. But prior to that, in RSA, they found quite silence and suppression of the fact. They never disclosed this fact before this court when the judgment passed. Judgment passed on 14/5/2015. This is, my
Judgment
lord.
in the title suit.
Yeah, no, my lord. This is RSA. RSA
No,
number, my lord.
This 14/5/2000
69/2004. Judgment passed on 14/5/2015.
in RSA.
Lordship. 14/5/2015. And on behalf of sole respondent, the counsel was Mr. A.K. Ali and Hamidur Rahman on record. But they did not disclose the fact that the sole respondent died on 7/10/2011.
Who, you were the appellant
I am appealing
in the RSA.
RSA. But sole respondent died on 7/10/2011. But on behalf of sole respondent, the counsel appeared, A.K. Ali, Hamidur Rahman, did not disclose. Therefore, the court passed the judgment. Court has not committed any mistake.
What was the judgment? The appeal was allowed or dismissed?
Appeal dismissed.
Appeal was dismissed.
Even abated, as appeal abated, so whether passed, dismissed or allowed, it's infractions. Because against that person.
Okay,
the
thereafter
judgment
what
passed.
happened?
Against that person, judgment passed. So therefore, this petition, I filed this substitution petition to bring on record, and this abatement, this is a process
This IA 4250 is for?
for condonation of delay regarding substitute the legal heir and for abatement of this
Oh my God.
appeal, my lord. Abatement is a process when defendant, because this abatement against the defendant, not against the plaintiff. When abated, then application is to be moved under Order 22 Rule 9. But that was not preferred during the relevant time. And when I come to know, this is the relevant, when I come to know, Your Honor, page, my lord, I have enclosed here, page 70 in Lordship 4250.
ROIS.
4250. Now, affidavit filed in CRP number 209/2019. Now, my lord,
No, this IA is for setting aside the abatement
yes, Lordship.
or for condoning the delay in.
This, my lord, 3 my lord. One,
Let us
this is
take one by one.
4250 condonation for delay to bring the bring
Condonation.
To set aside the abatement
Okay.
to and another, my lord, the IA
No, let us go to that IA later on.
Lordship. 4250.
4250
Yes.
instead of 150 days.
Lordship. I'm coming
You
to that.
filed.
4250, Your Honor, that they filed other side one affidavit in reply in CRP number 209/2019, page 17, madam.
I'm taking a short break. 1, 2 minutes.
To bring on record. And one of the court says that as a appeal itself abated, so to set aside the abatement, petition is necessary. And therefore, with liberty, this review petition along with substitution petition was withdrawn. That is page my lord 16. On the submission of Mr. We are learned counsel for the petitioner, this matter is allowed to
But
be
there is
withdrawn.
no indication that you came to know about the death on that day.
Lordship, this affidavit in opposition, page 17, my lord.
No, when you came to know about the death.
Yes.
What is your,
I have
Sir.
narrated, my lord, when I came to know, page 11 in my petition, paragraph 4, I have very specifically narrated. Page 11, my lord. That on 19/11/2019, the petitioner came to know the exact date of deceased respondent number 1 from the counsel of the petitioner after perusal affidavit in reply filed by the LR in CRP number so and so. Hence, the cause of action for reckoning limitation to set aside abatement start from date of the respondent number 1 on so and so. So when we come to know the date of knowledge, and within 90 days, this limitation condemnation petition filed, because statutory period 90 days to file a petition for abatement of to set aside the abatement. For setting aside abatement, limitation is 90 days, and within 90 days after acquiring the knowledge is filed. So this limitation is properly excellent. Not beyond 90 days. If beyond 90 days from the date of knowledge, then not maintainable. Otherwise, maintainable. And there is no any intentional delay because they inform. Other side, my lord, inform before the court, and disclose the date by filing this affidavit in reply and stated under my lord paragraph B, page 19, that it deserved to be mentioned that during pending of the hearing of the appeal in the Honorable High Court, the plaintiff, Respondent Abdul Gofur, died on 7/10/2011. But why they did not disclose when hearing was conducted? RSA. When RSA lordship dismissed on 14/5/2016, the counsel also present before the Honorable Court, but they was found keep silence. They did not disclose.
okay,
And now at this stage, when this IA, my lord, CRP number 209, this CRP was arising out of execution suit. And execution suit, against execution suit, the petitioner stand that without succession certificate, how they can claim for share of this property. And the Honorable Court, this Honorable Court held that regarding immovable property, succession certificate is not necessary. And therefore, this IA also been dismissed.
let us not go into those questions. Now the question is whether the abatement, your delay in filing the application for setting aside abatement should be condoned or not.
Exactly.
Whether you have shown sufficient cost.
Yes,
This is the limited.
I have this thing I have narrated, my lord.
You have only narrated that you came to know about the death of the appellant and death of the respondent in a connected civil division petition IO. Only on which date? On 19/11/2019.
So on 19/11/2009, cause of action start. Until filing of this condemnation petition. Condemnation petition filed on 4/12/2019. And knowledge, regarding knowledge of date on 19/11/2019. So within 90 days, Because,
Yes.
because city aside abatement is to be filed within 90 days. And previous period is to be condoned. So total lapse from 7/10/2011, because 7/10/2011, the sole respondent demise. And till filing the condonation petition was filed 4/12/2019. So ultimately it reckoned 8 years, 1 month, 28 days. So 7 years, 9 months, 28 days. So almost 10 years. So therefore, statutory time to file abatement petition is 90 days, is to be excluded from the total lapse period. Therefore, 8 years, 1 month, 28 days minus 90 days equal to 7 years, 9 months, 28 days is to be condoned.
Yes.
And this setting aside abatement to bring legal heirs on record.
May please the lordship. I will bring to the notice of your lordship the address of these two families, page 2 of this petition filed by my other side. Page 2, there is a mention about the address of Nur Islam, Nur Muhammad, Nur Salam, that they are residents of village Hatijana, Moza Khilazari, Borpata, Assam. Then at page 6, Gopur, the respondent who died, his address is given. His wife Sitron Nessa and 8 others, wife of Abdul Gopur, village Hatijana, Moza Khilazari, post office Hauli, district Borpata. My lord, these two families, they are from the same ancestor. They live nearby each other. So, the death of Abdul Gopur was not to be repeated by anyone else because they are from the same family and they even attended the funeral, the janaza of Abdul Gopur. These persons, they are from the same family, they are origin one. Nobody was required to inform them because they were not living somewhere else, not even the village, adjacent to one another. So, question of not getting the information of death of Abdul Gopur cannot arise at all. They got the information, they were involved in everything, they were present in the last rites, performance of last rites, and other necessary even social ceremonies.
No,
What happened?
but the council was under a duty to inform the court. When the death of respondent occurred in the year 2011, the council was obliged to
Yeah,
inform
my
the
lord,
court.
because the council was under the impression that they are very much well aware and they are not taking the interest to substitute it.
No, no.
On record,
Council's
it was
duty
not there
was
from
towards
outside.
the court. Council should have informed the court.
Yes, my lord, that is there, but they were fully aware about this for that reason because they already lost in 2 other courts. High Court only detoured, Honorable High Court only detoured the courts because there is, if had there been a reversal in absence of this Gopur, then something could have been argued. But only the other judgments which were already delivered by the 2 courts, and that is concurrent finding is approved by the Honorable High Court. Abatement that time, because High Court delivered the judgment as if Gopur was alive. So the merit was considered, on merit it was disposed of. Only thing is that he was not on record. Substitution was not on record. That lapse is there, but it is their duty. They were fully aware about the death of Abdul Gopur as they have lost the cases in all the 3 courts. They were sitting there without anything. When execution started, only they again came forward to object it. 8 years delay, my lord, not 1 or 2 days, 1 year or 2 years, 8 years delay. So, my lord, it is just only a tactics to stumble the progress of the case. This judgment of the Honorable High Court is there. We are not even able to get the fruit of the judgment. Last 24 years, the case is pending in all the 3 courts. honorable court may consider the entire material and dismiss this petition.
Lordship, I would like to delay.
No, the question would be, if if the appeal abates, if the appeal has already abated,
Elevated.
within, if there is no substitution made within the period of limitation,
Yes.
the, by operation of law, appeal would get abated. In the year 2011 itself, the respondent died. The judgment came in the year
15,
2014. When the
2015,
2015,
14/5/2015.
15. So after death of the respondent,
Sole respondent.
sole respondent, the appeal
Abated.
abated against that respondent
That respondent.
by operation of law. Now you have come for setting aside of abatement, but in the meanwhile, judgment has already been passed. What will happen to that judgment?
Lordship. Regarding abatement.
No, suppose the abatement is set aside
Lordship.
and your substitution petition is also allowed.
Allowed. Then appeal is to be heard fresh. Appeal, I am not saying another new amendment because the RS is to be heard.
No, but unless the appeal, the order of the appellate court is set aside, if that remains, why the appeal should have to be heard again?
Because judgment passed against the
But-
after abated. Because appeal shall abated. So when abated, that abatement,
So
the
that
process
question
is to be set aside. And Lordship, recent judgment passed by the Honorable Supreme Court on 5/8/2024, comprising my Lord Justice Arvind Kumar and Sandeep Mehta, and saying my Lord para 20 that length of delay is not necessary.
No.
Question
those-
is, my lord,
those
whether
co-
cause of delay appropriately stated, paragraph 20, my lord. My case, length of delay is long. That is not the issue.
No, what is your answer to the query, to the submission that you are from the same village? So obviously you,
No, question is
And you-
on record in the village, number of people dying each and every day. Who can keep in mind? And without any record, how the plaintiff side or appellant side can submit before the court? How can submit without any record, without any authentic document? When they file affidavit in opposition and say that on such and such date died, then I can take step. Then yes, on such date, if died, then why they keep upset? Not disclose at the appellate when the appeal was heard. It is their duty because the appeal was abated against the sole respondent, not against me. So it is their duty to disclose before the court. They did not disclose, and the two counsel was present at the
no,
time of hearing.
what would be the fate of the judgment?
Which, my lord, judge
No,
was saying that
you listen to my query, answer to my query, if necessary on some other day. The, by operation of law, the appeal got abated after 150 days of the death of the sole respondent. But court was not informed by the council as required under Rule 10,
exactly.
10A.
Lordship.
So the hearing proceeded, and after 4 years, the judgment was delivered in the appeal, as has happened in this case.
Lordship. After a
What
long
would-
period, after a long period,
No,
they
no,
did-
listen to my query.
Now-
What would happen to that judgment?
no, that judgment infractions, my lord, because
You
when
bring a,
when already been abated against that person, the judgment passed. So that judgment
No,
is to be
you-
that
you-
appeal is to be heard afresh.
on that point, you make
Some law.
some submission supported by some authority.
Lordship. That's all.
We'll hear it again. You also what would happen to that appeal? Which, what, that judgment which court passed without,
That becomes nullity.
no, the judgment would remain.
That
But-
problem is there. This is the judgment of the Honorable High Court, how it has to be. If it is said that it is a nullity, then also it is a problem.
You
Against
answer,
that person.
both of you answer my query.
No, the judgment passed on this one court beyond the knowledge because this was not disclosed from the side of the sole respondent.
No, yes.
It is the duty of the sole
The other way,
respondent.
my lord, it can be said, not disclosed. They did not bring it to the notice of the Honorable Court because they were fully aware of this.
No,
their
it is,
obligation.
it is
No, it
their
is your
duty.
duty.
No.
Why?
Rule
whatever-
10A says,
if-
Rule
if
10A
they-
says.
if They were
Your
not.
client
Just-
demise.
just let-
Your client, no, your
Third-
client demise.
third
You have
Mr.
you have
Kim,
disclosed.
If they were living somewhere else,
Third
Why
Mr. Kim,
they were very much aware.
Submit such
Learned counsel for the
Why you
applicant,
submit such a fact?
also heard Mr. A.
Your
Alam,
client
learned
demise. You have to
counsel for the
submit.
respondent.
You have to disclose. Why I?
During the course, please,
My side.
during the course of the hearing, a query was posed to the learned counsel for the
Not mislead the court.
both the sides as to what would be the fate of
I'll try to mislead.
the judgment which is passed by the court after abatement of the appeal against the sole defendant, sole respondent. The learned counsel for both these parties sought some time to answer to the query. The prayer is allowed. Let this matter be listed again on when will you answer?
For before my lord, before vacation.
Suggested date. Suggested date,
Before vacation. my lord.
4th of October 2020.
Hi, Lokesh. Meet these.
Your lordship may kindly see the office note dated 5/9/2024. The service in regard to all the respondents is complete.
All the respondents.
Yes, 1, 1, 2, 3, 4, and 5.
Heard Mr. S. Datta, learned counsel for the appellant. What for this IA is?
This is the IA for setting aside abatement. In regard to the sole respondent.
It appears from the office note dated 5/9/2024 that the notice is issued to respondent number 1 within bracket small Roman 1, 1 within bracket small Roman 2, 1 small Roman 3, 1 small Roman 4, and 1 small Roman 5 have returned after due service. This application is within the period of limitation.
There is, yes, within, no, there is a delay also, delay in substituting of legal aids.
No, if there is a delay in setting, then the delay has condonation application has to be there.
No, this is within limitation, setting aside abatement.
When the who died? Sole
The
respondent.
sole respondent
When?
died on 10/11/2018. Page 6, para 5. Lordship will find.
10/11/2018. একটু আগর কেস রাখো। And when have you filed this application under order?
Your lordship, sometime in the month of November, towards the end of November.
It is filed in the month of 17 December 2019,
Yes.
after 1 year.
After
So there is a delay,
delay.
so that application has to be there for condoning the delay.
So we'll have to file another application.
You decide.
If some time may be granted in that circumstance.
So the notices are held to be duly served on respondent number. Served on the opposite parties. Stop. Let this case be listed again after a week on a date to be fixed. by-
Your lordship, let it be listed after vacation.
After
In
vacation,
the meantime, we'll take instruction from
on the
the
date to be fixed by registry.
obliged.
Lordship, allow us 2 weeks time to take fresh steps, Lordship.
Why have you not taken steps? Earlier also there was a direction.
Earlier, we took steps, Lordship.
Steps for issuance of notice on respondent number 6. Heard Miss M. Deka.
For respondent number 6, Lordship, appearing on behalf of S. Nampal.
M. Deka, who prays for some more time to take steps for issuance of notice on the other respondent except respondent number 6 in pursuant to the directions given by this court on earlier occasions. Also heard Miss
B. Bora.
B. Bora appearing for respondent number 6. The prayer is allowed. The petitioner shall take steps, fresh steps for issuance of notice on the remaining respondents at their proper address within 2 weeks from the date of this order, returnable after 4 weeks. List accordingly.
Highly obliged.
Wait, Your Lordship. This has been listed as our instance, Lord. But perhaps the records have not come, my Lord, in this case. There is a cross appeal by respondent. So it can be fixed for an early.
Who is
hearing.
for the appeal? You are for the appellant.
I am for the appeal, Lord. And there is a cross appeal also tagged along with that, my Lord, by the insurance company.
By the insurance companies. Now what has happened?
But
Service is
Record.
not complete and LCR has not been received, Lords.
there was an, while admitting, Lord, your Lordship has called for the records, Lord, that has not come.
And you have not taken steps for issuance of notice on respondent number 2 and respondent number 3. You have to take fresh steps.
Lord, will take that.
Heard Mr. R. Dubey, learned counsel for the appellant. Also heard Mr. S.T. Sharma,
Respondent number one, Lordship.
learned counsel appearing for respondent number 1.
Yes.
It appears from record that the common order of him. No, the cross appeal is not listed.
It's been listed, not tagged
Listed.
along in item
Tagged.
15 itself.
It appears from the record that the
Number to the
records of MAC case number
17 of 2008. madam.
17 of 2018 8 has not yet been received from the concerned tribunal. Issue reminder for the same. It also appears from the office note dated 28/7/2023 that the notices issued to respondent number 2 and 3 has not yet been served. The appellant is therefore directed to take fresh steps for issuance of notice on respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Lordship, as per last order, notice on respondent number 2 has not been served. It has returned unserved. And I am, Lordship, the original suit, I am the defendant number 1, and the respondent number 2 is the defendant number 2. I have purchased a plot of land through defendant number 2. He was the seller, vendor. He was a power of attorney holder. So court has directed me to serve the copy to him, keep the address. Lordship, today I have verified, we have tried our level best to collect the address where he is now. Now we have verified the record, and one Pranab Sharma was appearing on the behalf of the respondent number 2 in the court. And Guwahati High Court rules also specifically stated, I have given the copy of the Guwahati High Court rules, that copy may be served to the counsel representing the original court. So I have informed him, he has come, his junior has come, okay? He can accept notice on respondent number 2. He may serve the copy and his name may be soon in the court cause list. His junior has come, he will accept the notice.
Okay. Heard
He will
Mr.
serve the copy to him, Lordship.
Where is the provision?
Provision I have given, Lordship. That has been amended by the Guwahati High Court. Page 425. Page 425. Lordship will find advance notice. Lordship will find 3. Advance notice should be simultaneously served. Simultaneously given to the counsel for the party who is proposing to file appeal to the counsel for the opposite party.
Where are you reading? Page?
Page 425. 425. I have flag mark, Lordship. Serial number Roman 3, Lordship.
Yes.
Roman 3, Lordship, got it. Service of notice on appeal, Lordship, got it.
Yes.
Service of notice on appeal.
Yes.
Now, before that, after second paragraph, Lordship, advance notice should be simultaneously be given by the counsel for the party who is proposing to file appeal to the counsel for the opposite party who appeared in the subordinate court so as to enable the respondents to appear if they choose even at the first hearing of this case. So he can appear, Lordship. And in order 41 also there is a provision. He can appear. He will take the instruction from his counsel.
Where is the provision in order 41?
Order 41 also there is a provision without Okalatama also he can appear in the appellate court.
Heard Mr. S.K. Goswami, learned counsel for the
Lordship, it has not been followed in Guwahati High Court till date. It has been amended, I think, in 2020 or 22 for advance hearing of all appeals. That is why that amendment has been come into effect. Lordship. That was not pointed out to the court in many occasions by the counsel representing the appellant also.
What is your name?
M. K. Sharma.
Heard Mr. M. K. Sharma, learned counsel for the appellant. Also heard Mr. S. K. Goswami, learned counsel for the respondent number 1. Also heard Mr.
Sir, A. Borbujari, appearing on behalf of Mr. P. K. Sharma.
Mr. A. Borpujari, appearing on behalf of Mr. A. K. Sharma, learned counsel for the petitioner. Learned counsel for respondent number 1 has submitted that the Mr. A. K. Sharma,
P.K. Sharma
Mr. P. K. Sharma was the engaged counsel for respondent number 2
in the trial court.
in the trial court. And therefore, as per the provision
Of Guwahati High Court rules, Lord, sir. Civil rules and orders.
of Guwahati High Court rules, within case management rules. As per the provisions of trial court and first appellate court. But this is this rule which you are showing is applicable to subordinate courts only.
Not only civil, first appeal also. It is also first appeal.
First appeal in subordinate courts.
First appeal in subordinate court. That is why, Lordship, in order 41 also that has been stated.
Where?
Lordship, I can show the order 41. CPC also.
CPC Diop.
After some time, Lordship, take this matter. After this matter,
But the rule which you are showing is a case management rules,
Lordship, case management rules.
which
And there is Lordship, amendment to that effect also. Case management rule, that is why case has been delayed. That is why, Lordship, this has been inserted. Huh? No question.
but you are accepting that notice.
Lordship, he is accepting, Lordship. I have informed me by telephone. His senior, I
But
have,
you show me that.
Lordship, I'll
provision.
show you. After some time, Lordship. I'll show the provision.
I'll pass orders after you.
After 5 minutes.
Okay. Call next. It will be certain.
Hello, I made my appearance on behalf of respondent number 1.
How many respondents are
There
there?
are 2 respondents. 2 has already appeared.
Heard Mr. A. Singh,
A Singh, Lordship.
A. Singh, learned counsel for the petitioner.
And thus, my lord, for respondent number 1.
Also heard Mr. N. Das, appearing for respondent number 1, as well as Mr. R. Senswa, appearing for respondent number 2. The service of notice on respondents. Only 2 respondents are
Only 2 respondents.
in this case is complete. Let this case be listed for admission hearing.
Lordship,
November.
short date maybe.
Hello, let it be on the first week of November. In the meantime, if any affidavit is required.
Should be
The pleadings,
usually before vacation.
Not before it. What is the matter? What is the matter?
Lordship, the CRP has been filed against the order of.
let me say, there is an order of injunction. They came and filed an application regarding the violation of the injunction application is pending. In spite of that, they came and filed an application under order 39 rule 7 for preservation of the smooth land. That was dismissed, against that they preferred the CRP.
Otherwise, the purpose why they have filed this application is already served.
Exactly, my lord.
I'll show that how it is served. Already
Okay.
it is moved.
Let this matter be listed in the
First week of November, my lord, any date.
After puja vacation on a date to be fixed by registry.
After in the first week of November.
In the first week of November on a date to be fixed by registry.
Lordship, can we see?
Yes.
Order 41, Rule 14.
Order 41 rule
Order 41, Rule 14,
14.
14, 41, Rule 14, Sub Rule 2. Lordship got it, Sub Rule 2.
Hmm.
Instead of sending notice to the court from whose decree appeal is referred, the appellate court may itself cause the notice to be served on the respondent or on the pleader under the provision above referred to, on the pleader who is representing the counsel.
Okay. क्या लिखा था? Mr. AC. Stop. P.K. Sharma, who was the engaged counsel in the trial court appearing for
Respondent number 2.
Respondent, no. Defendant number 2.
Defendant number 2. Right.
Defendant number 2. The counsel for respondent is allowed to accept the notice on behalf of respondent number 2.
And
The-
he will be allowed directly to serve copy to
The
him.
appellant shall furnish a copy of memo of appeal along with the annexures to the counsel for respondent number 2.
And his name will be shown in the cause list, P.K. Sharma.
The name of
My senior name will be
P.K. Sharma.
whether he had
He will take instruction from his clients for appearance and Lordship is serving the copy to him, Lordship, as per this provision.
whether he needs to file a separate wakalat number.
No, not required. That is also already there is a provision, so we go judgment on this point.
Where is the provision?
There is judgment to this effect. I'll give the copy, Lordship, registry.
Where is the judgment?
I'll give the copy, Lordship.
Then,
No need to file a Okaltam also.
okay. But I am not passing orders now. Let this case be listed for hearing. The service is complete.
Service
It
is
will
complete.
come for admission.
It is no,
The-
already admitted, already admitted.
The substantial question of law has been formulated.
Formulated.
Then it will go for hearing.
Here.
Let this case be listed for hearing. On a date to be fixed by registry.
Right.
You show me that provision.
I will give the copy.
All right.
Obliged.
Yeah, please, your lordship. Lord, in this case, I have a limited prayer, my lord. I am challenging here in my lord, the mode of disbursement of award, my lord. There is a similar judgment, my lord, I have annexed here with my lord.
No, why it has come up for orders? Whether, who is appearing for respondents?
As per cause with DZ does, I may be allowed to call him, my lord.
Yes, what is the issue?
My lord, I am challenging here in my lord, the mode of disbursement of an award, my lord. 8 lakhs rupees was granted, my lord, awarded, my lord, in my favor, my lord. But the trial court, my lord.
DJ Das is appearing for whom?
For respondent, Union of India, Railway.
Okay, and you are appearing for?
I am appearing on his behalf, my lord.
Okay, okay.
My lord, directed to pay in several installment, my lord. Therefore, I have challenged the mode of disbursement, my lord. I have required some money, my lord, because I am seriously ill, my lord. I am in bed rest condition, my lord. And Similar order, my lord, I have next page number 24, my lords.
Now, why this matter has come up for orders? We'll fix it for admission hearing.
Yes, ma'am.
Heard Mr. F. A. Laskar, learned counsel for the appellants. Also heard Ms. A. Gayan, learned CGC, appearing on behalf of sole respondent.
Sole respondent.
Sole respondent. Let this matter be listed for admission hearing after 2 weeks on a date to be fixed by the ministry.
Obliged.
Master.
Lordship, in this case, what happened while considering the condonation application, Lordship, Mr. B. Chakraborty appeared and filed his wakalatnama. And later on, at the time of admission hearing, we informed that, but again he missed the item, so appeal was admitted on 8/2, Lordship.
Second appeal.
Yes, Lordship. 2/8/2023, appeal was admitted. Now I have gone through the file whether title records have received or not. I have found that, Lordship, on 2/8, there was no order for calling the LCR, Lordship.
Okay, we'll call for the LCR.
Yes, Lordship.
What was, you were the defendant or plaintiff in the
I'm
original?
independent, Lordship.
Suit was,
Suit was for recovery of possession.
suit was decreed
Yes, Lordship.
in the first appellate court?
Lordship, in my against, concurrent finding, Lordship. And we have filed one application for under order 41 rule 5, that is IA civil number 1554.
What has happened to that?
Lordship, only notice was, maybe it was directed that after the appearance of the respondent, my stay petition will be considered on the day of admission, Lordship.
Now, whether any execution has been filed? No.
Execution,
Then why this has come for orders in orders column?
Lordship, as IA is pending. And there is no service report as yet, Lordship. So maybe they are appearing for the respondents. So what can I appear for that?
You are appearing for all respondents.
The respondents.
Then we'll fix this case for hearing.
Lordship, no, Lordship, the records. to be
Okay,
called for.
records have to be called. Heard Miss R. Chaudhary, learned counsel for the appellants. Also heard Miss, what is your name?
A. Sharma,
A. Sharma, appearing for the
on behalf of B. Chakraborty.
appearing on behalf of Mr. B. Chakraborty, learned counsel for the respondents. How many respondents are there?
6 respondents.
All
Lordship.
the respondents
Yes, Lordship.
on behalf
One
of
was
all the respondents. Whether records were called for.
No, Lordship, 2/8/2023, appeal was only admitted.
It appears that the records of the first appellate court and trial court have not yet been called for. Perusal of same would be necessary for consideration of this second appeal. Hence, call for the record of the trial court. Call for the record of title suit number
41/2011.
41/2011 as well as title
Title
appeal number 29/2018
29/2018.
from the concerned courts. Registry to issue requisition for the same. List this matter after receipt of the records.
Lordship, my prayer in the IA, Lordship, if in the meantime execution, Lordship, the decree has been put to execution, I will be evicted. So your Lordship may consider my IA till the disposal of the RSA, Lordship. Otherwise, the RSA will become.
Whether execution has been filed now.
Lordship, at that relevant point of time, we have prayed for only for the stay at the operation of the judgment and decree. So whether they have filed by way of additional affidavit, I can bring that.
You may let then I remain.
Even if they do not file any execution proceeding, Lordship, if my appeal has already been admitted, it is a right to the appellant to get a stay order in the.
No, there is no such right. if there is an apprehension that decree may be
Yes,
executed,
but there
only
is a-
then the question of,
See, there is an apprehension as the decree
But-
was for recovery of possession.
but execution case has not yet been filed. You may press for that stay application, stay of execution under order 41 rule 5 at any time.
Yes, Lordship, I have already filed
No, you have filed.
order 41, rule 5.
You have anything to submit?
Lordship, my senior is not here.
Yes, let her senior come. Then we will
Lordship, then record, then in IA, my prayer will be considered on next day.
yes, the prayer for on receipt of the records.
No, Lordship, on next date, your Lordship may fix a date for consideration of the IA
In
only. Yes.
I told you.
Before the records, Lordship, because records, it will take some time. Phone number. Sorry, yes.
You find out whether they have filed any execution application or not.
Lordship.
Because it is stay of, your prayer is for stay of operation of judgment and decree.
Yes, Lordship, I have filed it is in the year 2023.
No, but there is no provision for stay of operation of judgment and decree. Provision is there only for stay of execution. Whether such a relief may be granted.
Lordship may fix this matter after 1 week. In the meantime, if they want to file any objection, they can file or
Okay. Heard Miss R. Chaudhary, learned counsel for the petitioner. Also heard Miss
A. Sharma.
A. Sharma, learned counsel appearing for the, no, instead of petitioner applicant, learned counsel appearing for the opposite parties. Let this matter be listed again. When do you want?
after 1 week, Lordship.
Again, after 1 week on a date to be fixed by registry. In the
A fixed
meanwhile,
date may be given, Lordship.
in the
Otherwise,
meanwhile,
again,
the opposite party may file written objection if they so desire.
Yes, Lordship. On 25th September. Today is Lordship. 18th,
Okay, on 25th September.
Lordship. I'm deeply obliged.
Release this matter on 25th September.
Deeply obliged.
Man, item number 20.
My lord, here this I have been filed for correction of the my lord order that was passed on, my lord. That is on 26, 2018, my lord. Annexure 3. Actually, what happened, my lord? That was the disposal order and the entire MSCT was, my lord, disposed of. And prior to that, my lord, there was an order. It is
No,
annexure.
no, I'm not getting you.
My lord.
Which, why this I has been filed?
Yes, my lord, I am coming to
For
that, my- I am coming, my
which
lord.
order?
My
Modification?
lord, this is an order annexure 3 that is to be modified. My lord,
Page
annexure
number, tell me the page.
Yes, my lord, this is at page
24.
24, my lord. 11% will start from 24.
What modification is?
My lord, actually the amount has already been deposited 20 lakhs. And as per the honorable court order that was passed on, my lord, 2/5/2016, the amount was accordingly, my lord, paid to the claimant and withdrawn with a certain criteria that the amount 10 lakhs was given to the, my lord, claimant number 1, and 2 and 3, that is another 5 lakhs was fixed deposited till they are attaining the majority, my lord. And after the subsequent disorder, the honorable court disposed the entire matter, that is by annexure 3 at page, my lord, started from
This is
24.
for modification.
Yes, my lord. So now the again, my lord, court has given a direction with a subsequent criteria that the how the amount will be, my lord, disposed of that paid to the my claimant. Because as the already the amount has been, my lord, already paid and that is been withdrawn to the claimant. So, my lord, this,
But it should go to the same
So-
judge who passed the order.
my lord, that can be your
Because,
lordship.
no, it is in the nature of like review only. because this is not clerical modification.
Yes, it is true, my lord. That your
It
lordship
ne-
can do, my
It
lord.
needs application, it should go to the same judge if he's,
As your lordship, my lord. But my prayer is that, my lord, one sort that will be given because, my lord, they.
the
Is another
counsel
thing,
for
my
the
lord.
applicants. Also heard Mr. R. Goswami, learned counsel for respondent number 1.
He is for one.
This interlocutory application has been filed by the applicants applicants claimant. You are claimants also.
Yes,
Applicants claimants / claimants seeking modification of order dated
dated, my lord, 18. At 28, 26, 2018, my lord.
26, 2018, passed in MSc Appeal number 103/2016. Stop. On perusal of the record, it appears that the said order was passed by a coordinate bench of this court within bracket Dibo, Honorable Mr. Justice K.R. Surana. Stop. The registry shall, this court is of considered opinion that this matter should be placed before the same court which passed the said order, which passed the order of which modification is prayed for. Stop. The registry shall, therefore, list this matter before appropriate bench. Appropriate bench on a date to be fixed by it.
Date is given, your lordship.
I don't know where that, because availability of that judge is required. Registry will fix it.
Must. Must.
My lord, my lord, here we have a regular second appeal, my lord. In that appeal, 17 days delay was there. In that delay, my lord, this honorable could issue notice, my lord. But from the notice, it reveals that 2 persons respondents have already expired before filing the second appeal. So we have filed substitution application, my lord, and that substitution application also, my lord, there is a delay. So on the last occasion, my lord, we have we are directed to take steps, my lord. Accordingly, my lord, I have instructed my clerk, but my lord, from the record, it reveals that no steps has been taken, my lord. So, my lord, within tomorrow, my lord, I will take steps, my lord. My lord, we may be allowed to, my lord, serve this notice to Dusty, my lord. In IA number 2981.
2981.
Yes.
Heard Mr. K. Singha, learned counsel for the applicant / appellant. You are appearing for?
For respondent number 3, 4, 7, 8, 9, 10, 3 to 10, 9.
Also heard Mr.
M. Hussain, my lord.
M. Hussain appearing for respondent number 3, 4, 7, 10,
8, 9,
8, 9,
10, 3
10 within bracket 3
to 10, 9.
to 10 within bracket 9. Against other respondents, you have to take steps.
Yes, my lord. My lord, my respondent number, my lord, 6 and 10-1 already expired. So, my lord, on the last occasion, we are directed to take step to the legal heir of this respondent number 6 and 10-1. So, we will be allowed to, my lord, take step to register as well as my trustee, my lord.
No, as regards other respondents,
Other respondent, my lord.
number 1,
8, 5, 1, 2, 1, 2, 5.
there is no notice, no report regarding.
My lord.
You have to take steps against all the respondents.
My lord. Except, my lord, this.
Except the
Yes, my lord.
those who have appeared. Who is six?
My lord, six, six is my lord,
Muhammad Saleha,
Saleha Begum, my lord,
she has died.
died. my lord. And my lord, 10-1. Syed Sarif Ahmed.
Then you have to file an application for substituting.
Then already we have filed, my lord.
Where?
Here, my lord, in the second, regular second appeal, my lord, delay was there for 17 days. When we served the notice to that delay application, now that information come up that these 2 persons have expired. So we have filed substitution, and in that substitution there was delay, so abatement petition has been filed, my lord, for setting aside. And that abatement petition, my lord, 62 days delay was there, so this delay application has been filed. 2981. My lord, substitution petition is my lord 2977. I at 2977. Two nine seven seven is a
No,
substitution.
but the substitution petition would come later on. After abatement, before that abatement has to be set aside.
Yes, my lord. Abatement petition is my lord 29.
But there is a delay in filing abatement.
Yes,
petition.
my lord.
That delay has to be condoned.
Yes, my lord.
No, my lord. Notice was issued on delay petition. They have not taken steps. My lord.
No, that I am saying.
Yes.
Before allowing the setting aside of abatement application, the delay has to be condoned.
Yes.
For condoning the delay, notice has to go to the other sides.
Yes.
And in your condonation of delay application, you have again shown respondent number 6 as a party.
My lord, here because this new legal here, still not, my lord, they are not allowed, they are not substituted till date. That's why, my lord. Already we have mentioned in the substitution petition, my lord.
No, without substituting them, how can you send notice to them?
Yes, my lord.
And how can you send a notice to dead person?
Then, my lord, we may be allowed to correct this my lord, delay application, my lord.
No, you take steps against other respondents.
Yes.
Learned counsel for the petition applicant shall take steps for issuance of notice on the other opposite parties who are not represented by Mr.
M. Hussain.
M. Hussain, and on whom the notice have not yet been served. So the applicant shall take steps within
But more, my lord.
within 3 days from the date of this order by registered post with AD as well as by usual mode, returnable after 4 weeks.
My lord, we will allow my lord Dusty as well. Solve that.
Stop. Learned counsel for the applicant is also allowed to take steps in addition to aforesaid modes by way of Dusty for service of notice on the applicant, on the respondents by way of Dusty. Stop. After effecting the service of notice through Dusty mode, the applicant shall file an affidavit of in compliance before this court on the next date fixed. Let this case be listed accordingly after 4 weeks.
Most obliged.
Yes, 3850 is for
Regarding substitution.
3850 is for condonation of delay.
Yes, my lord, regarding substitution of respondent number 4, my lord. My lord, I am stating in paragraph 4, my lord. Paragraph 3, my lord, page.
Total appeal to the
Paragraph
सब शरत रखेंगे. You Tera
paragraph 3, my lord. That on 3/6/2019, when the RSA number 309 of 18 was posted before this honorable court for necessary order, the learned counsel appeared on behalf of the respondent number 1 to 3, 4 to 9 and 11, apprised this honorable court that the respondent number 4 and 10 had expired. My lord, 10, my lord, regarding legal hair of 10, my lord, already on record. Then 4 is the Narayan Chandra Pal. Therefore, on request of the petitioners, the learned counsel of the above respondents furnished copies of death certificates of the respondent number 4 and 10 on 9/8/19. The legal heirs of Orunabala Pal, wife of late Chittaranjan Pal, are already on record and hence not required to be substituted face. Then, my lord, paragraph 6, my lord. But accordingly, my lord, in both the two cases, my lord, I prepared IS and handed over to my advocate's clerk to file before the honorable court. Annexure 6, my lord, paragraph 6, my lord. The mention may be made herein that advocate's clerk, Sri Hitesh Burman, perhaps filed 2 IS in case number ISC 306, well, in another appeal on 19/11/19, and by mistake he did not file other 2 IS in RSA number 309. The said clerk was under impression that he filed all the applications in both the appeals. My lord, he has shown affidavit, my lord. So that's why, my lord, in other RSA, my lord, IA number 354 and 353, 2019, my lord, that was filed, my lord. But here in this RSA, my lord, he was under impression that he filed all the IAs in both the cases, my lord. Then paragraph 8, my lord, that on 30/8/23, paragraph 8, the counsel for the appellant's petitioner searched about the interlocutory application filed in the RSA number 309 in connection with substitution of legal heirs of respondent number 4, Narayan Chandra Pal. But surprisingly, the said 2 petitions were not found in the court record, although the personal copies available in the personal brief of the concerned advocate. The counsel immediately asked her advocates, Sri Hitesh Burman, as to whether said 2 petitions in RSA number 309 of 18 were actually filed or not. The said clerk, after making thorough search, could not trace the said 2 petitions, and he is under impression that by mistake said 2 petitions were not filed in the said RSA number 309 of 18. Hence, these 2 fresh petitions under section 5 of the Limitation Act, paying for condonation delay by setting aside abatement period, as well as petition for substitution of legal heirs of respondent number 4 being filed before the honorable court for passing necessary order. My lord, that's why the delay has been caused, my lord. That is 2018 days, my lord.
How many? 2018?
Yes, my lord, in another RSA, my lord, 306, delay was only for
No, 306 is not before us. Oh, 306 is
Yes.
next item.
Yes.
Next.
No, first, my lord.
First, let us discuss this.
Yes, my lord.
Le-
First, my lord, Lordship may kindly be this item number 23.
Your submission is that your clerk made the mistake.
Yes, yes.
And
That's
due
why I have to file a fresh applications again. In 306, that was filed.
no,
as,
let us not go to 306.
well, he has shown affidavit, my lord.
In where?
My lord, this is my lord. He filed affidavit, my lord, by mistake, my lord. That was happened. In affidavit, my lordship will file. I am an advocate's clerk of the Guwahati High Court. It is a fact that I was entrusted by the engaged counsel for filing interlocutory applications for condonation of delay, as well as for
No,
substitution of
whether the negligence of advocate clerks
my lord,
may be a sufficient ground to condone the delay. That is the question. If you can,
since he has shown the affidavit disclosing his, that is not negligence, my lord, by mistake, my lord. That is a bona fide mistake. And he has stated that, but under mistaken belief, I was under
But
impression that I
2018
filed the
days-
applications.
2018
both
days
RS.
means 5 years. How many years?
2018,
6.
6 years.
delay of
more than 6 years.
My lord, on 3/6/19, my lord, when my senior colleague, my lord, told me
My
about
lord,
the
there are two
date of,
things, my lord, regarding
my
substitution.
lord, from his mouth, my lord, we came to know about that, as because the,
No, as
the
soon as
residents
you
of the respondents are not at Sabarmukh. My lord, they are, although here in the plain, my lord, it has been stated as the resident of Sabarmukh, but they are the residents of Morigaon, my lord, since before 1960, my lord, and it is, and death certificate also revealed his death resident is at Morigaon, my lord. These are death certificates. His residence shown as, my lord.
when the
So we
now
could not trace, my lord, about the date of the respondent number 4. So from the mouth of my colleague,
when
my,
he died, respondent number 4.
my lord, he died on 18/12/2017, my lord.
So assuming that you came to know about his death on 9/8/2019, when he furnished the death certificate,
Yes.
or even before that, when in the month of June, the
3/6/2019.
council informed about the death. From that point of time, 150 days have.
On 3/6/19, we came to know, my lord, from his mouth, my lord. When he disclosed the honorable court, then we came to know. Then we approached him to supply death certificate, thereafter we filed it.
My lord, in this case, the two petitions to be filed. First to condonation.
Setting
of-
aside abatement.
Yes. and
That is not there.
Not there.
Well, I filed composite petition, my lord.
No.
Composite petition cannot be allowed. Because there are two
Yeah.
things. Condonation regarding substitution and also for abatement. Two things, two petitions is to be filed.
We filed two sets of court fees, my lord. In earlier
No.
occasion also regarding appellant number 4, my lord, that was substituted,
No,
my
but
lord.
there is
legally.
no prayer for setting aside abatement.
My
Is,
lord, there
is
is
there,
prayer, my
is
lord.
there a
There is prayer for setting aside abatement, but not for the substitution.
By setting aside the abatement period.
In all the petitions, this
Condonation
defect
fees
is
by
going
setting
on.
aside the abatement period, my lord.
All the petitions have been abated.
Then I may file, my lord, another petition also. No?
No, this application 3850. 3850 is for condonation of delay in filing substitution petition. But substitution will come only after abatement is set
Abatement is
aside.
set aside.
You have to file an application for setting aside abatement first.
I filed.
Then only this question will arise.
My lord, there is a Supreme Court decision also, my lord, regarding, my lord,
No.
substitution without filing abatement, setting aside abatement, my lord, it is implied, my lord. Court has power to conduct
Sure.
the delay also
No.
by
That-
setting aside abatement, my lord.
Show that.
My
If-
lord, in the short date may be given, I will show your lordship, or I will file a petition again, for setting aside abatement, no doubt. To satisfy the court and to satisfy my colleague also, my lord.
No, your colleague will never be satisfied. Heard Miss B. Devi, learned counsel for the applicant, also heard Mr. R.K. Jain, learned counsel for the learned counsel for all opposite parties.
No, my lord.
For whom you are referring?
Just me.
All the respondents.
All the respondents.
Yes,
In this application, there are 11 opposite parties. Learned counsel for opposite party number so and so, number 2 logo.
I
Learned-
filed for the respondent number 1.
Only respondent number 1. Then
Affidavit 1 or 5.
Then what will happen to other respondents? Notice will have to go against other opposite parties. Because in earlier order, you were shown as appearing for all the opposite
All
parties.
respondents,
No,
my
but
lord.
some of the respond,
We appear all the respondents, my lord, except 4 and 10.
yes.
Learned counsel for opposite parties except opposite party number 4 and 10. Who is 4?
4 is my lord, Narayan Chandra Pal, and
Who has
10
expired?
is Varunabala Das.
See, that's,
Legal heirs of Varunabala Das are already on record, my lord.
No, but without substitution, how they can be on record?
petition is to be filed.
Okay. Some time to, for what?
For an IA, for setting aside abatement.
Or filing an
Abatement of-
application, appropriate application for setting aside abatement,
Abatement of appeal.
abatement on of appeal on the death of respondent number 4.
4.
Narayan
10
Chand-
are already on record.
Narayan Chandrapal, the prayer is allowed. Let this matter be listed after
4 weeks,
After-
my client has to come.
4 weeks on a date to be fixed by registry.
My lord, in all the IAs, this defect is there. In all the IAs,
I will file in all the IS.
Otherwise, some. This, no, 20, this is item number 22. IA 3851, some.
3854. Awesome.
This is for substitution
Unless the abatement is set aside,
of respondent number 4. This is for, no, 3851 can be taken up only after
Yes.
condoning the delay.
Yes.
Delay in filing substitution. And that can be taken up only after setting aside abatement. So we will not pass any orders in those IAs. You file
To file.
you file an application for setting aside abatement, thereafter we'll pass. After 4 weeks. We are not passing orders in other IAs.
Not so good.
And same order in
306.
item number 23. Same order.
Item 24.
What is this?
Here we request some time to take some instruction, madam.
What is this first?
This is
Sir, Lordship, this is the application for condonation of delay for under order 9, rule 9 for this
Setting aside ex parte
setting,
order.
Lordship. Sir, what happened actually, Lordship, there was a delay in filing application before the lower court. And we have, the lower court has dismissed the application, then we came before this High Court. This Honorable High Court as page number 6 has passed in a judgment, condoning my delay.
How much time you require?
not 1 week time only.
Let her file.
Lordship, one submission.
this matter is of 83, 84, 40 years, 4 decades. It may be.
Whether it was pending before district judge's court also,
It was there.
Sonitpur district judge court also. At any point of time, whether this case was pending before Sonitpur district judge court also or not.
It was there because advocates, they were doing that, but now the senior
No, no.
advocate is no more.
No,
That's
because
why-
records are not before me. But name appears to be familiar. So whether I was there or not, therefore,
Oh,
if
but
I
that-
handle this case,
eh,
then
sir,
I may not take up this matter.
This case was of civil judge, Lordship.
No, therefore I am asking whether
Acha.
this case,
He was there at the point.
this is an arbitration matter.
This was arbitration
Arbitration
matter,
matter.
Lordship.
Okay, let us give her time today.
Yes, ma'am. Because-
Tomorrow may kindly, Lordship.
Not
Okay.
tomorrow,
Lordship,
is
I
not-
used to come from Chandigarh, Lordship, to deal this case. It is very old
Yes,
case.
madam, I will take instruction.
When?
Tomorrow,
Tomorrow, Lordship,
day after tomorrow.
not day after tomorrow.
No, you come again after some time.
And that's, no, it's a, Lordship, it is. very-
Or you can appear through VC also, instead of coming personally.
Then next week, I'll stay here with my brother. Okay, then I'll do.
Heard Mr. G.
Ghanshyam Das
G.
Dimankar.
Das appearing petitioner in person. Petitioner appearing in persons. Stop. Also heard Miss A. Gayan, learned CGC
For all the respondents.
for appearing for all the respondent. Who prays for some time for filing written objection. The prayer is allowed. Let this matter be listed again. When? In the
30th of September.
30, on 30 September 2020.
Obliged, Lord.
Last time. Madam, 21 kindly pass up that for the time being, madam. The learned council is in another court, madam.
After some time.
Item 26. May I please take your question? Lordship, I will stay awaited in this matter, your Lordship. In respect of respondent number 1, 2, and 3, your Lordship.
The report has not yet received.
Yes, Lordship.
So we have to await.
Yes,
Lord, we are appearing formula respondent number 21, 23 to 28.
21 to 28.
21, 23 to 28.
Not appearing for respondent number 22.
21, 23, 1%.
Heard Mr. What is your name?
Yes, Lordship.
What is your name?
T. Gogoi, your Lordship.
Heard Mr. T. Gogoi, learned counsel for the applicant. Also heard Mr. M.U. Mandal.
M.U. Mandal.
Appearing for respondent number 21, 23 to 28. On perusal of the office note dated 7/3/2000. No, on office note dated
Probably 24.
24/6/2024, it appears that the notices issued to respondent number 1 and 2 within bracket 2 has not yet returned. Have not yet returned. Stop. Await further. Let this matter be listed after 4 weeks.
Obliged.
Wait, please, Your Lordship. My lord, office note dated 12/9 may be soon. Service is complete and our court records, I think, has also come.
Five respondents were there. Heard Mr. D. Chakravarti, learned counsel for the appellants. On perusal of office note dated 12/9/2024, it appears that flag X. It appears that the notices issued to all the respondents are duly served. Duly served on the respondents. Stop. I have gone through the report of process servers annexed available in the case record. Stop. The notices issued to respondent number, all the respondents are therefore held to be duly served. Let this case record has not.
It has been received, madam.
No,
It's
LCR.
it's reflected in that office note itself. LCR, I think it's.
याद कोई गिनतो though the office notes shows that the records of the trial court as well as first appellate court have been received. However, same is not available with the case record registry to verify the same and list this matter again. When?
After vacation.
After vacation.
Interim is
On a date to be fixed by registry.
Interim is there in the IA, madam.
Interim is there.
In the IA, yes.
In
That
a-
was till the returnable date, so Your Lordship may be.
In I heard Mr. D. Chakravarti, learned counsel for the applicant. Hmm. It appears from the office note dated. What was the office note date?
My lord, here there is a
In-
confusion. In IA, it has been reflected that no steps has been received, but if Your Lordship peruses the steps in the main appeal, we had taken steps of both appeal
IA also.
as well as IA.
Okay, it appears from the office note dated 13/9/2024 that no steps have been taken for issuance of notice. However, learned counsel for the applicant submits that the applicant has taken steps for issuance of notice to the opposite party in the main appeal. Stop. On verification of the records of the main appeal, it appears that the applicant has taken steps for issuance of notice on the opposite parties. The notices are held to be duly served on the opposite parties. Stop. No one has appeared for the opposite parties. Stop. Therefore, the interim stay granted, interim stay on the execution of the interim stay granted by order dated 2/8/2024 is hereby made absolute till the pendency of the connected regular second appeal, that is RSA number 142/2024. This interlocutory application is accordingly disposed of.
Keep your pleasure.
May it please the loss. My lord, in this appeal, the appeal number 1 died, my lord. So there is delay of 314 days. In this connection, I have filed 3 applications, my lord. One for setting aside the abatement. This is number is 191. And another for condonation of delay, which is numbered as 220. And the last one is for substitution. So my learned friend is appearing for the respondents, my lord. And now he is agreeable that delay may be condoned, matter be taken up. He is interested for the final hearing of the appeal, my lord.
How many ayes are there? Setting aside
There are
abate,
3 ayes, my lord. First one is 199. This is for setting aside abatement.
heard Mr. M. H. Raj Bhuya, learned counsel for the applicants / appellants. Also heard Mr.
J. Das.
J. Das, appearing for the
Respondent number 1A to 1I.
1A to 1I. This application. Now, is there any delay in filing this application?
There is a delay of 314 days, man.
For condoning that delay, you have
I have filed application. This is number is 220, my lord.
you are not opposing. Because setting aside abatement, application also has to be filed within a certain period of limitation. There is a limitation for filing that application.
Yes, ma'am.
What is the period of limitation?
My lord,
What is that period?
for limitation period is 314 days, my lord.
No.
No,
What is the period within which you should file an application for setting aside abatement? Is there any limitation period?
in my
This-
application number 199, my lord, I mentioned that the setting aside abatement took place on 29/11/2023. Page 12, my last page, you lost me. After 90 days, it gets abated, my lord, so. Where to file this setting aside or abatement? Limitation at section 120, my lord.
What it provides?
Hmm?
Article 120 of Limitation Act.
Yes, ma'am.
What it provides?
Article 121, ma'am.
Please read.
It's under 60 days delay, ma'am. Period of 60 days.
No, read it.
Under the same for foreign order to set aside an abatement, 60 days, ma'am.
So after the suit is abated, within 60 days, you have to file an application for
condonation of debt.
for setting aside that abatement.
Yes, my lord.
But you have not come within 60 days. So there is a delay in approaching this court for setting aside abatement also. Is there any delay or not?
The total delay, as you have calculated, it is 414 days, my lord. So as per the Limitation Act, I am to file the setting aside within 90 days, my lord. 19 days has to be minus. Anyway, my
No,
lord,
no, my query is, suppose after the date of abatement, the suit gets abated after 90 days
90 days.
of the death of the
Death of the person
party,
concerned.
if there is no substitution. Suppose there is no substitution within 90 days,
Then
suit
it
will
gets
get
abated.
abated. Now from the day, that date of abatement, you
The
get again.
Delay has
60
to be
No,
counted.
no, you get again 60 days period for setting aside abatement.
Abated.
So you have not approached this court within that 60 days. You have, there is a delay in approaching court for setting aside abatement also. Therefore, whether an application under section 5 is required for for condoning that delay. Am I clear?
Yes. Yes.
So make me understand. Your suit got abated after 90 days of the death of the
Person concerned.
person concerned. Whether your application for setting aside abatement is within 60 days of that date of abatement. If it is within 60 days, if he agrees, I will allow. If it is not within 60 days, then an application is required for condoning the delay, whether an application is required or not. You have to answer. I'm not saying that this has to be done or this is not to be done. I have my own queries. You have to answer these queries. In this case, man died in the year 2022.
Yes, so I have annexed the death certificate, my lord.
Yes.
And page 14 of my in IA 199. Date of
2020.
that is 31/8/2022, my lord.
So then 3 months is 9, 10, 11. 31/11/2022, suit gets abated.
Yeah.
In the month of November, suit gets abated.
He
From
died
the-
on 31/8/2022.
Yes, 31 August 2022, he died.
Died, my
So in the-
September, October, November.
On 31 November, lapse of 31 November 2022, your suit get abated.
Abated.
Now, after that abatement, you get again another 60 days of time for setting aside abatement
Abatement.
under Article 121.
121.
But you have not approached the court within, whether have you approached within that 60 days? No.
No, yes, no.
Then
We filed it on as per the
11 October 2023.
on the 10th October 2023, my lord.
Then there is a delay in filing this setting aside abatement application also.
Yes.
So unless that delay is condoned, whether this can be entertained. That is my
Because of
question.
this, my lord, I have filed first application is 199, which is for setting aside abatement.
Yes, setting aside abatement also has to be within the period of limitation.
Yes.
Because law prescribes a period of limitation for that.
They are, as per their information, they are not aware of these things, my lord, because of which all the delay took place.
No, that may be a good reason for condoning the delay. that you were not in,
Filing of delay condemnation may be required.
but delay condonation application, whether it is required or not. You answer this query. Then we'll take it up. If required, you have to file an application. If you can satisfy that it is not required, then we can go ahead.
This respect, I could not exactly follow. I will have to think about the matter, my lord. I am not.
You
aware.
understood my query. Let me put my query again. On 31/8/2022, appellant number 1 died.
Yes, ma'am.
Then
By 30th
within
November.
90 days, his legal heir ought to have been substituted
Yes, ma'am.
within 90 days.
90 days.
You have not substituted it within those 90 days.
Yes.
As a result of which the
Appeal gets abated.
appeal gets abated. Then from the date of abatement, Limitation Act 121 provides that you get another 60 days time for filing an application for setting aside
Setting
abatement.
aside, right.
Now you have not approached this court
They could
within
not
60 days for some reasons.
Yes.
Then you have approached this court after delay of some days,
Yes.
after 60 days.
Yes.
Then whether that delay has to be condoned or not before taking up setting aside abatement application. That is my query. If it is to be, if it is required, that application has to be there. If it is not required, you have to satisfy me that why it is not required. This is my query. You answer my query on any date which you may choose. Tomorrow, day after tomorrow, next week.
So let it be taken on Monday, my lord.
Okay. On request of Mr. M.H. Raj Bordhuier, learned counsel for the applicant, let this case be listed again on 23rd September 2024.
Yes.
Item 30.
Criminal liability. What is this?
Yeah, please. What's it? It has been filed for modification of order dated 24/6/2024, Lordship. In AB number 501/24, Lordship, Annex D, page number 24, Lordship.
Page number?
24, Lordship.
What is the modification required?
Wherein Lordship directed me to appear before the trial court and file appropriate application, Your Lordship, relevant portion, page number 26, Your Lordship.
Yes, what
Hence,
happened?
the petitioner is directed to appear before the trial court within 7 days from the date of this order. Thereafter, may make prayer for bail application before the said court, if so advised. So, Lordship, then Lordship, I have another file, Lordship, criminal 662/24, Lordship. And Lordship, only because of that, Lordship, my name has been wrongly mentioned in the state bail anticipated bail application as Abdul Kasem, Lordship, instead of Abul Kasem, Lordship. So, Lordship, that is the Annexer B, page number 17, Lordship, criminal 662/24, Lordship.
No, what you are seeking in this
So
interlocutor?
now, Lordship, my prayer is that, Lordship, although two direction, Lordship, has been passed by this honorable court, wherein directed me to approach before the trial court, Lordship, and file appropriate application, Lordship, but I have filed appropriate application
But in the instant FIR Lordship, wherein page number 10, FIR dated 26/1/2024 Lordship, having Sotia PS case number 13/21 Lordship, but the instant FIR name has been mentioned as Kasem Ali, Mohammad Kasem Ali. But my earlier bail application has been filed, which is my actual name Lordship, Abul Kasem Lordship. So Lordship, the learned trial court, that is the district and session judge, refused to accept my bail application, stated that Lordship, my name has been mentioned in the instant FIR Lordship, Mohammad Kasem Ali Lordship, not Abul Kasem, either Abdul Kasem. So Lordship, only because of that Lordship, I have filed the present IA Lordship, wherein please be issue direction, at least accepted my two different number of AB as well as the interlocutor
No,
bail
no,
application.
no, that is,
I am the same in one person Lordship, even Lordship.
that
in the
direction
meantime-
cannot be issued by this court. If there is a typographical mistake,
No,
if-
earlier Lordship, due to typographical mistake, Lordship, another IA has been filed, wherein modification of my order, Lordship, Abul Qasim instead of Abdul Qasim. That is okay, Lordship. But Lordship, earlier Lordship, in the same PS case number, Lordship, kindly peruse the FIR Lordship dated 26/1/2024 Lordship, FIR page number 10 Lordship, kindly be perused. In the instant FIR Lordship, relevant page number, that is the type copy Lordship, Mohammad Kasem Ali Lord. The referent PS case number is remain the same Lord.
maybe
And the relevant
Now
portion,
that-
your Lordship.
that you sought and you approached this court seeking a bail. Court gave certain directions.
In that case, they have not corrected their names, in the FIR, first application, bail application.
Then Lordship, case remain the same Lordship. I am not the same and same person Lordship. The case has been remain pending as the Kasem Ali, Mohammad Kasem Ali. Mohammad Kasem Ali. Yes, Lordship, I admitted Lordship. I am involved in such criminal cases, Lordship, which was pending before the trial court as well as the reference Sotia PS case number showing. So I am willing to participate it and file application before the authority, Lordship, but refuse to accept, Lordship.
This is an interlocutory application filed in an anticipatory bail application.
Yes,
In the anticipatory bail application, an order was passed
yes,
where there was some error in the mentioning of your name.
yes.
On your application, that error was rectified.
Correct.
This,
I admit, earlier one occasion.
no, listen to me.
There has been active.
Now,
but
if you have any problem, that is not because of the order passed by this court. So,
But Lordship, the case reference, the PS case number, as well as the another Lordship, session case number has remained the same. I am the person Lordship, as well as me Lordship. I am willing to appear before the trial court Lordship, and trial court
no,
refused.
that we will not.
Lordship, no.
No.
Your bail application,
Now, what do you want?
Lordship,
You want
me finish,
me to
Lordship?
issue?
I
No,
have
what do you want now?
now I want Lordship, I am the
That-
allegation
that
that
inst-
alleged me Lordship in the instant affair, Mohammad Kasem Ali Lordship, I am the person concerned.
You want this court to say that you are Muhammad, both are same person.
Yeah, Mohammad Kasem. Yes,
How
I am the
this court,
Mohammad
how
Kasem.
this court will verify?
Yes, I have made affidavit Lordship.
You
And it-
make
and
that
the
affidavit before the trial court. You go with
trial
that.
court has refused to accept my application. That is why I am coming Lordship. Can you peruse my affidavit?
Then you challenge that order, refusal order. But in this interlocutory application, such orders,
Cannot be
such
passed by-
directions cannot be passed.
lord.
Whether you are one and the same person
Same
or
person,
not.
that court cannot decide,
This, we have modified your
order,
app-
if there is mistake,
name.
Yes, that
Typographical
is
mistake.
admitted fact. Yes, Lordship, the trial court must have to pass the appropriate order on basis of my application. But very whimsically, Lordship, learned trial, district and session case, judge has refused to accept my bail application only because of that, Lordship, the earlier two
Where is that,
different order
where
passed
is-
by this honorable High Court,
Where is that ever, listen to me,
Lordship.
where is that ever meant? The trial court has
Yes,
refused.
that is why,
Where
I
is
am
that
coming.
ever meant?
In the petition, where is
No.
it?
Lordship, I have approached, but refused to accept,
is it?
Lordship. That is why I am coming, Lordship. That is my grievances. The High Court has already made and clear observation, Lordship, directed me to the same case reference, Lordship.
What is your
appear
name?
before the trial court, Lordship.
What is your name?
My name is Abul Qasim, Lordship.
Not your client's name. I want your name.
Mintu Soikia, Lordship.
Mr. Soikia,
Yes, sir.
you show me the averment. Where have you mentioned that trial court is refusing to accept your?
Yes.
You have mentioned it in,
It's Lordship, even Lordship.
you show me that averment. The trial court is not entertaining your application. Heard, Mr.
In para number 4, Lordship.
This is item number.
30, my lord, 30, my lord.
Para number 4, Lordship, page number 5, Lordship. The trial court has refused to accept.
Para number,
Para number 4, Lordship.
page.
Page number 5.
Heard, Mr. M. Soikia, learned counsel for the applicant. If you stay, accept your application, this interlocutory application has been filed. Also, heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application has been filed by the petitioner Abul Qasim. What is your name?
Abul Qasim is the actual name
My
on
lord,
basis
Lordship,
of
page
the PAN.
15, my lord, vernacular, my lord. In the FIR, his name was Muhammad Qasim Ali.
Yes, yes, that is why I am coming.
Thereafter, he, in the IA, my lord, Abul Qasim.
What is your name? You know your name.
My lord.
Abul
Actual name.
Qasim is my actual name on
Then
basis of the.
why are
on
you
basis-
using alias of Qasim Ali in your application? If somebody calls you Mintu Soikia, instead of Mintu Soikia, somebody calls you Mintu Hajorika.
Yes.
Will you start writing alias Mintu Hajorika? You will not start writing.
But Lordship, in such cases involve me, Lordship, and my.
So you will change your name in your application. Your name. Heard, Miss. This application is filed by applicant Abul Qasim, praying for modification of order dated 1/8/2024, passed in IA within bracket criminal number 662/2024 in AB case number 501/2024. Learned counsel for the petitioner has submitted that the name of the petitioner. No, the petitioner was, where is the original bail order?
Bill of the annexer.
Page number.
Page number 24, annexer D, your Lordship.
Not the bail order, but he is directed to appear. my lord.
Yes, directed to
Within
appear.
7 days, my lord.
By-
26, my
by
lord.
By
bail
order
order.
dated 24/6/2024, passed in AB case number 501/2024. The petitioner was directed to appear before the trial court
Within 7 days.
within 7 days from the date of the said order. However, thereafter, the petitioner again approached this court by filing an interlocutory application, which was registered as IA within brackets CRL 662/2024, wherein the petitioner has submitted that in the order dated 24/6/2024, the name of the petitioner was wrongly mentioned as Abdul Qasim instead of Abul
Abul
Qasim.
Qasim.
And after hearing the council and after going through the record, the said error was rectified by this court by passing order dated 1/8/2024 in IA Criminal 662/2024, whereby it was ordered that wherever the name Abdul Qasim is appearing in order dated 24/6/2024, same shall be read as Abul Qasim. Stop. Now, stop, next para. Now learned counsel for the petitioner has submitted that when the petitioner approached the trial court on which date you have approached?
That is not categorically mentioned here. Lordship. But within stipulated period, I went and approached.
The trial court. What court refused to accept your application?
The district and session judge.
No, what it refused? Your application was not accepted.
Accepted here.
No order was passed.
No order was passed.
The trial court refused to accept the application regarding surrender of the regarding appearance of the petitioner before the said court, and no order was passed on the said application. Though the truthfulness of the statement made by the petitioner alleging that wherein it has been alleged that the application was not entertained by the trial court and no order was passed thereon, cannot be verified. However, as same is supported by an affidavit filed by the petitioner, hence this interlocutory application is disposed of with a direction that if the petitioner appears before the trial court within next 7 days, the trial court shall consider the application and pass appropriate orders thereon.
My lord, in the earlier order, page 26, my lord, the petitioner is directed to appear before the trial court within 7 days from the date of the order, and thereafter may make prayer for bail before the said court if so advised. He was not granted bail, my lord. His only direction was
only given.
only 7 days he will appear. Thereafter he will
No,
file
there is
bail
no
petition.
direction for grant for bail.
No, my lord.
No specific
Have
direction,
you-
but directed
have
to
you
it to
filed
file
an-
appropriate application.
Have you filed any bail application?
Yes, Lordship. When I went and
Where is the
went
statement
to
that you filed a bail
went to
application?
file application,
Where
Lordship,
is the
but-
statement?
But in para number 4, Lordship, I stated that.
Only said that
refused
it
to
was-
accept, Lordship.
What
But
what
in
was
the
refused?
Lordship, the bench clerk, Lordship, has to be acknowledged, but the bench clerk as well as the concerned court, Lordship, stated that.
I am not going by your
Mhm.
oral submissions. Where is the statement? Where have you made those statements?
That is mentioned in para number 4, Lordship. The trial court has refused to accept the
Refuse
statement.
to accept what?
What petition for what purpose?
What?
What petition
That
filed?
is
That
all
was not mentioned.
so and so and the AB number so and so.
Yes. Next 7 days.
My lord.
7 days, and files an application for bail. Same shall be considered by the trial court as per law.
As per law, my lord.
With this observation, this interlocutory application is disposed of.
Yes, that is now.
you have to, before you make submissions, you have to plead your case in the application. Therefore, you are filing an
And
application,
bail
a
application
written
that was
application.
rejected after not.
But you have not pleaded your case. You have not made statement before this court. Okay, appear before.
No, sir, I will appeal. I'll appeal.
Dispose of
Deep-
matter.
Hey, please, your lordship. Here in the second appeal, my lord, I am for the appellant defendant. My lord, during the pendency, my lord, respondent number 2 and 4 expired. On being informed by my learned friend, I have filed the IS, one for substitution of legal heirs, one for continuation of delay in for substitution of legal heirs, and one for abatement of automatic abatement of the suit. So, my lord, perhaps I am also required to file one as your lordship bench point in another case.
No,
for
you go through the law and
continuation of
follow.
delay, continuation of delay for this abatement petition, my lord.
You have to set aside, pray for setting aside abatement.
Yes.
If abatement is set aside, then question of substitution will come.
Yes.
Heard Mr.
Take a
G. A.K. Talukdar, learned counsel for the applicant. Also heard Mr. B. Sarkar.
T Roy,
T. Roy, learned counsel for respondents.
2 to 6.
Number 2 to 6. On request of learned counsel for the applicant, this case is adjourned for today. Let this matter be listed
After vacation, my lord, because law.
after puja vacations on a date to be fixed by registry.
This IA is for granting of temporary injunction, lordship.
And for
Restraining-
what?
Granting of temporary injunction. Restraining the opposite party from.
Temporary injunction. Main appeal. You are appellant.
I am appellant, lordship.
You are appellant. This, what injunction you are seeking? You will file objection.
I will file objection. So it was, the appeal is already admitted and a record were called for, my lord. In the meantime, they are filing this of injunction application. In the execution proceeding, right? Execution, there was the execution proceeding, my lord.
No, you were plaintiff in the main suit or
I'm the
defendant?
defendant.
Defendant. Suit was dismissed.
It was dismissed. Decreed in their favor, my lord.
Suit was decreed. And then the first appeal was against you.
Yes, my lord. Then we approached this honorable court, my lord. This honorable court admit this appeal, my lord, second
Okay,
appeal.
okay.
And the.
So the property is in your possession. Therefore, they are apprehending that you may sell it.
And lordship, we have already paid the remaining balance, which is reflected in annexure number, annexure A.
Case will be decided in the appeal, my lord. If the final outcome of the appeal will, my lord, the position will be delivered to them or not, that will be decided, my lord. But when the appeal has been admitted for final hearing, my lord, that cannot be now in this position, my lord. The injunction, question of injunction doesn't arise, my lord. Although, my lord, they are already protected under section 52 of the Transfer of Property Act.
Okay, you file objection.
I will file
Written objection. Heard Miss, what is your name? R. Sahar, learned counsel for the respondent slash learned counsel for the applicant slash respondent. Also heard Mr. Shiladitya, learned counsel for the for all the opposite parties
I'm the appellant, my lord. I'm the appellant.
or the appellant slash opposite party. This application under Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908 has been filed by the applicant slash respondent praying for grant of temporary injunction restraining the opposite party slash appellant from selling or alienating the sought land or creating any form of third party right over the suit land during the pendency of the appeal. Since Mr. Shiladitya has appeared for the opposite party, no formal notice need to be issued. The learned counsel for the opposite party prays for allowing some time to file written objection against the application. The prayer is allowed. Let this case be listed when?
After vacation.
After 4 weeks on a date to be fixed by the list. In main appeal, how many respondents are there?
All are appeared.
All have appeared.
They appeared for all. They have appeared, man.
Heard
Only one.
Heard Mr. Shiladitya, learned counsel for the appellant, as well as Miss R. Saha.
Yes.
R. Saha appearing for
Respondent number 1.
respondent number 1. On perusal of the office note dated 25/7/2024, it appears that the notices to other respondents have returned with an endorsement that respondent number 5 and respondent number 2 have expired, and respondent number 3 and respondent number 4 could not be located. And as regards the other respondents, also no service report has been received by the registry of this court. In view of the report, in view of above, the appellant is directed to take. You have to take steps for appropriate steps as regards the respondent number 2 and 5, and shall take fresh steps for issuance of notice to other respondents by registered post with AD as well as by usual mode. Stop. The record of title suit number 86/21 as well as title appeal number 31 record of title suit number 81/21 has been received. However, the record of title appeal number 31/22 has not yet been received. Issue reminder for the same. Registry to issue reminder. List this matter after 4 weeks.
Obliged.
So in this case, I am for the appellant, Lordship, and during pendency of the appeal, Lordship, they have started construction over the suit land. So I have filed this injunction application.
I may be allowed to file objection, madam.
My case is that, Lordship, I have filed it in the month of May, and thereafter on being made.
It shows there is no urgency because she has filed in the month of May. Now it is September.
Lordship, on June.
But if you are constructing building.
No, I am not.
It will, what is constructing?
Undertaking, Lordship, if they
No,
lost
I
in the.
cannot
appeal,
give
Lordship.
understanding unless there is instruction from my client.
In this case, suit was decreed by the trial court and first appellate court, Lordship, reversed that judgment. Against that, I have filed my
Suit for?
suit for right title interest and recovery of possession.
Possession is with the,
With me.
Yes. From the very beginning, we are admitting they are in possession, but lordship, my suit property may be protected, lordship.
suit is suit land or building.
Suit land, lordship.
Now, what
They are
what
residing.
you are apprehending?
They have, lordship, as per information, they received some yojana from government, lordship. And as per that assistance, they have started construction. And we filed an FIR also, that also I have annexed along with my.
Is there
injunction.
any stay?
No, lordship, there is
No stay.
No stay.
stay.
Then
now.
you go for execution.
No, lordship, I have lost before the first appellate court.
Or you have lost?
Yes.
Okay.
So
Then
I
you have to
prefer-
wait till the
Yes, I'm.
By that
outcome
time,
of this.
lordship, the appeal has already been admitted. In this situation, it is normally, lordship, suit property has to be protected. So
No,
I,
if your allegations are true, that has to be
Yes.
found out.
yes, lordship, I have filed one FIR also, but the police is saying that the case is
FIR
pending
can-
before the. Honorable High
Now,
Court.
now this status is that court has recognized his right over the land, first appellate court, by dismissing your suit.
Yes, lordship, as well, lordship, this High Court also admitted my appeal. Lordship, as there is some
Only
points.
appeal has been admitted.
Admission
So no,
cannot
this
be.
can be heard, but he has to file objection.
Object.
On last 3-4 days, it was
No,
listed.
no, only one day.
No, in the month of June, lordship, it is listed 4 times, lordship.
Okay, when will you file your objection? Let them file.
Date may be given, lordship.
On second.
What he is constructing,
No, I am residing there, man.
what you
My
are
submission
apprehending.
is I am residing there.
Pradhan Mantri Yojana, lordship, something like that they have received from government, lordship. I have made a statement in my petition, lordship.
But there is
No,
no.
what you are
particulars.
apprehending, what he will do.
Paragraph 2, lordship. That the applicants are plaintiffs and their suit was for right title interest and recovery of possession. The learned trial court decreed the suit and the learned first appellate court reversed the same and hence challenging the said decree. The second appeal was filed. The defendants during pendency of the regular second appeal very recently started construction over the suit land as they have obtained some yojana from government.
There is no specific date.
And what is being constructed? What he is.
I am residing there, man.
Okay, let him file.
Lordship,
Heard Miss,
maybe
heard Miss Archod, when will you file?
On,
Heard,
within 1 week, lordship, they can
no,
file.
1 week I will be not here, my lord.
heard Miss R Chaudhary, learned counsel for the applicant.
On the third October. my lord.
Okay, also heard Mr. R K Jain, learned counsel for the opposite parties, who submits that some time may be granted to him for filing the written objection against the application for temporary injunction filed by the applicant. Prayer is allowed. Let this case be listed again on 3rd of October 2024. Before the said date, the opposite party shall submit their written objection with a copy to the other side.
And deeply applied.
May I please, your lordship? For the in the instant appeal, we have taken steps to register post. But the office had dated 12/9/24 shows that I have not taken step as the usual process. Lordship, I may be allowed to take steps as usual process. Today itself, I will take those steps.
Okay. In I only.
I am. This is for condoning the delay.
Okay, heard Mr. K. Hendick, learned counsel for the applicant, who prays for allowing some more time for taking steps for issuance of notice on the respondents as directed by order dated 2/8/2024. You take by both mode.
Lordship.
The prayer is allowed. Let this matter be listed. The petitioner shall take steps within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed accordingly after 4 weeks.
May I please, your lordships? I filed an application, lordship, internal application number 2630 for vacation of the interim order passed in the instant revision petition. My learned friend filed an objection petition against this. This is not on record. Matter be taken up on next Wednesday, lordship.
That is not on record. We have filed objection.
Okay, heard Mr. F. U. Borghuya, learned counsel for the applicant. Also heard Mr. N. Hussain, N. Hawk, learned counsel appearing for the petitioner, appearing for the opposite party. You are the petitioner.
Opposite party, civil revision petition.
And in this IA,
I am the lordship plaintiff respondents.
who has filed this IA? For vacating the
For vacating the interim order.
interim. What interim you have received?
My lord, status quo has, order was granted.
Learned counsel for the opposite party has submitted that.
Sorry, my
You know,
lord.
the state.
State.
Learned counsel
Passed
for
by
the
the learned
opposite
court
party has
legislation state.
submitted that the opposite party has filed a written objection against the prayer made by the applicant in this case. However, the said written objection is not on record. Stop. The registry shall place the written objection filed by the opposite party on record and list this matter again on
25/9.
25/9/2024. What for this IA? Oh, this CRP is
CRP, my lord, learned trial court passed an injunction order. And that order, we filed appeal before the learned civil judge senior division. My lord. In the meantime, the trial court passed another order under section 151. And for another injunction has been granted in favor of that plaintiff. That order we have challenged. That already there is injunction order. And that injunction order status quo was granted. Against that, we have filed a defendant filed an appeal. First appeal before the civil
what
judge.
has happened in that first appeal?
Now, first appeal is pending. In the meantime, they file a petition under
But no order has.
No order. That is pending.
So that status quo is still in force.
No, it's still in.
Earlier status quo.
In the meantime, but in respect of my scheduled land, status quo is there. We have no objection. In the meantime, they have filed an application under section 151. That is not a part of that scheduled land. They want actually one path. In the scheduled suit, there is a status quo order we followed, and against that order we filed appeal. That is pending status quo. The under 151 petition they have filed, and they want another route that is not a part of that suit land. That is second suit land. And then that order was passed under 151. And against that order we have filed this.
With the records will be required.
Possibly not required with that order.
No.
Not
No, I am not going into submission. I just wanted to know.
Whether
Even
record
if
is
he has
required.
made wrong
Record not
submissions, I got
required.
some idea.
Record is not
Whether
required.
records are required.
Possibly not required.
Not required.
Not required. Because
Okay, then we can take up the CRP also in the next.
yes,
On
that
next
that can be
In-
finally
instead
decided.
of-
Yes, that can also be decided.
Heard Mr. N. Hawk, learned counsel for the petitioner. Also heard Mr. F. U. Borghuya, learned counsel appearing for
Respond.
all respondents.
Respondents, lordship.
All respond,
All respondents.
all respondents. Learned counsel for both the parties have submitted that since the application has been filed along with requisite annexures, the requisition of original case record may not be required for the purpose of hearing of the instant civil revision petition. Hence, let this case be listed for admission hearing on,
25.
let it be in the next week,
Next week, any day.
Next week on 25.
not 25. Next hearing day. 26.
26. Yes.
Can it be 27?
27. Let it be on 27.
Obvious.
26 is best.
26, some problem. 27, my lord. Okay, so 27 code. It is,
Continuous for
in
P
admission,
27.
it will come on.
26 lordships.
In admission column, my lord, it will be.
Along with IR.
I will. No, if we
It finally decided ultimately.
will see
IA
if
may
we
also
can
be
finally
considered.
dispose of the,
Right.
because
That-
IA and this almost similar matters.
Similar. 27.
26.
26 is best lordship.
Let it be on 26.
26.
I'll-
No, please.
We'll admit it.
Okay, your lordship.
We'll admit it. And what is your submission?
Lordship. In the admission column, lordship, may please for hearing, lordship.
Okay, heard, Mr. What is your name?
D. Mahanta.
D. Mohanta, learned counsel for the appellants. Also, heard Mr. A. Datta, learned counsel for respondent number 3.
3, your lordship.
None has appeared for respondent number 1 and 2. This case is admitted for hearing. Let this case be listed for hearing after puja vacation on a date to be fixed by registry.
Lordship.
Much.
May I please? Lordship, matter pertains to transfer of a proceeding held by the respondent herein before the learned district and session judge Kamrup.
Lordship. I want to point out 2 points, Lordship, Your Lordship, before Lordship we start the main hearing, Lordship. Lordship, perhaps that will be relevant to the Lordship. First of all, Lordship, the case is Lordship proceeding ex parte against her Lordship. In the
Against?
her Lordship.
Okay.
In the first trial court, Lordship, I am the plaintiff, Lordship, and he is the defendant, opposite party, Lordship. He first appeared, Lordship, then again she perhaps derivative.
Who is she? Is there any relation?
Petitioner here.
Husband or
Husband, wife?
Yes, Lordship.
Okay.
Other husband, Lordship, now Lordship, she pleaded Lordship pro myself, Lordship, and even Lordship with their proof of divorce, Lordship, again she another marriage, Lordship, she claimed Lordship, and my child is with her Lordship, and with
Now,
that
now,
person.
what case is this which you want
Lord-
to transfer?
Lordship.
Divorce
Lord-
case,
Lordship may.
Transfer guardianship petition, Lordship.
guardianship petition.
Father, father,
Okay,
Lordship. I
what
filed
point you want to
guardianship
raise?
Lordship.
What you wanted
Yes,
to raise?
now Lordship, in that case, Lordship, she first appeared, Lordship, and filed double.
Guardianship case.
Yes, Lordship. And thereafter, Lordship, she deliberately, Lordship, she refused to appear before the court, Lordship. Now the case is, Lordship, proceeding ex parte, Lordship, against her Lordship. So, Lordship, she again filed a petition, Lordship, to vacate the said ex parte order, Lordship.
There.
Yes, in the trial court, Lordship. That petition is not now is pending, Lordship. And I also filed objection in the petition, Lordship, because she, Lordship, at least, Lordship, 4 Lordship. Now, Lordship.
Where is the case is pending guardianship?
The court of Aminio, Lordship.
I mean, where you want to transfer it?
She want to allow.
Borpeta, district and session judge, Borpeta.
Lordship, my first point is that, Lordship. Now, Lordship, she, Lordship, lodged the chance, Lordship, to contest the transfer petition, Lordship. Unless and until her death petition is allowed, Lordship.
No, that we may look at it in a different way.
Yes, that is
If
also.
transfer is allowed, only transfer will be allowed. Setting aside ex parte order is on the trial court. It may proceed ex parte in the transferred court also. In Borpeta also ex parte may be proceeded.
That is
Suppose
also. But actually, Lordship, the court, who is Lordship, actually passed the ex parte order, Lordship. That is the proper forum, Lordship, to hear the said petition, Lordship, because that court knows about the, Lordship, the conduct of the said person, Lordship.
no. Why you are not appearing? What is the ground?
Lordship.
Ground for transfer.
Ground is, yes, Lordship.
That petition, Your Lordship, first my humble submission is, Your Lordship. The first, let the argument was to complete on the petition, Lordship. If she can, Lordship, again get the chance. to
No, she
complete the
has
petition.
difficulty in going to.
No, her counsel will appeal, Lordship. That is not the she need not to appear before the court in this.
We'll decide it if her appearance is not necessary.
Necessary, Lordship. On
We
that
will
petition,
dismiss her
her
petition.
petition, Lordship. It is
Then we will
similar.
dismiss her petition after hearing her.
If that is
Now, whether
Lordship.
the case is stayed or going on,
No, case is going on, Lordship.
no stay is there.
No stay there, Lordship.
Okay.
So only that petition, Lordship, if she failed, then this case will become infectious, Lordship. And then, Lordship, there will not be necessary, Lordship, to transfer the case, Lordship. So only one date, Lordship, that date she can, Lordship, attempt, Lordship. From my side, objection also filed, Lordship. So now.
Ex
already the hearing-
parte, to proceed ex parte,
Yes, to proceed ex parte, Lordship.
but no ex parte order has.
No, final order is not, Lordship. To proceed ex parte.
Okay.
So, Lordship, if she can, Lordship, succeed, Lordship, then, Lordship, her claim will come, Lordship, that she can transfer the case from there, Lordship. Otherwise, Lordship, it is one aspect. Another aspect, Lordship, there is an interim order, Lordship, to bring the side, Lordship, to meet with me, Lordship. She's avoiding the interim order, Lordship. So, Lordship, first, Lordship, she had a made to habit to comply the order of the court, Lordship. Otherwise, Lordship, again, there will be order, Lordship, again, she will refuse, Lordship, that order, Lordship. So, Lordship, I think, Lordship, without complying this order, Lordship, she cannot get the benefit of this transfer petition, Lordship. First, Lordship, she have to make the habit to comply of order law. That what I have, Lordship, annexed here, Lordship.
Okay, let us hear the,
May I submit, Lordship?
yes.
Lordship, may kindly take the Guardian and Wards Act 1890, section 9.
Yes, you read slowly.
Lordship, court having jurisdiction to entertain application, section 9(1), Lordship. If the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. Main question is there, where the minor resides, ordinarily resides, Lordship. Lordships may kindly take my transfer petition.
Yes.
First title, page number 2.
Yes.
In the matter of Srimati Usma Sultana, village Patnabati Sahar, Bagbor, Alopati, Borpeta, Lordship. This is the address of the mother of the minor son, Lordship. And minor is with his mother. Minor is son, Lordship. Then the minor is residing with his mother and he is reading in Ankur class. Lordship made.
Yes.
Lordship may page 20, Lordship, of my transfer petition.
Yes.
Admission receipt, Lordship, which is under the Borpeta district and jurisdiction of Landed district and Sessions of Borpeta, Lordship. Now, Lordship.
He's a son or daughter?
Son, Lordship.
Your son is a student of?
Ankur class, Lordship.
Ankur.
Of Novanur Jatiyo Vidyalaya, Bhatnabati, sir.
How old is your son?
Now 6 years, Lordship.
Now 6 years, Lordship. Lordship.
Where he or he was born?
He was born on 4/5.
Where?
In my place, Lordship.
In his residence, Lordship.
Then when you came to Borpeta?
Thereafter, I fled away with another boy, remarried with him, and is staying with him. And child is with me.
When?
12/9/2022, Lordship.
So since 12/9/2022, you are residing at Borpeta?
Lordship, fled away, that is not mentioned, but through a notary, I have dissolved my marriage on 26/7/2022, dissolved
No, but since when the child is in Borpeta?
Child,
Child is in Borpeta since when?
since 26/7/2022,
Okay.
from the dissolution
Okay,
of marriage.
what is your other point?
Lordship. Lordship may take page 11, para 9 of my petition, Lordship. Paragraph 9, Lordship.
Yes.
That the petitioner basis that later on the petitioner came to know that the opposite party again married a person, namely Habibur Rahman, my present husband, Lordship, son of Shamsul Haq, a resident of village Bhatnabai Tisar, P.S. Allahabad Tisar in the district of Borpeta, Assam, through a marriage agreement, and since then they have been living as husband and wife. After admission, after giving this statement, they have filed a guardianship case saying that, yes, I have got remarried and living with him. Now, by filing the respondent disputing my marriage, that I have not properly dissolved my marriage.
That is not issue before this.
Lordship, that is not issue in the transfer petition, Lordship. Secondly, Lordship, the affidavit in opposition filed by the respondent, Lordship, page 27, Lordship.
Page 27.
Page 27. First paragraph, last sentence, Lordship. Therefore, the address of Sri Habibur Rahman will not be the place of ordinary residence of the son of the deponent. Therefore, the learned court, District Judge Borpeta, shall not be the jurisdictional court to proceed and decide the miscase, guardianship case number, so and so. Lordship, the respondent himself disputing his statement in the state abandonment made in the guardianship case and an abandonment made in the affidavit in opposition, Lordship. So my humble submission before your Lordship that
No. What plea has been taken by the respondent? Why it shall not be Borpeta court? What has been stated in para 7?
Lord.
In the affidavit in opposition?
That with regard to the abandonment made in
You can tell me the gist. Why he saying that Borpeta will not be the.
Lordship, he is disputing that the ordinary residence of the child, which I have taken as ground, is not the ordinary place, ordinary residence of the man.
Why? Why?
Without any.
No, what ground has been mentioned?
By virtue of, because his ground is that I have remarried and the child is with me, which is illegal marriage.
Okay.
Lordship, which plea is not applicable, and my marriage, dissolution of marriage, subsequent marriage, they have not challenged anywhere. So the respondent have not any locus to submit like this disputed question of fact, Lordship. Lastly, I am relying a judgment before your Lordship regarding ordinary residence, Lordship, nothing more.
কপি আছে এটা
Lordship may take paragraph 7, Lordship. May I read, Lordship?
Yes.
In Muhammad Firoza Begum versus Akhtaruddin Lashkar, AR 1963, Assam, 193, a division bench of this court considered the said subsection. In that case, two petitions were filed. One before the learned district judge Kasar at Silchar,
and another before the learned additional district judge Guwahati, and the minors were living with their mother at Kasar. This court held that as the minors had been residing at Silchar for about 3 years, the learned district judge Silchar had jurisdiction as the requirement of section 9 of the ordinary residence was satisfied. In Simanlal Gupta versus Swanso held that under the Opposite Act, in order to give the court jurisdiction to the minor must be ordinarily resident within the local limits of the jurisdiction of the court. The same view was expressed in Sharada Nair versus Swanso, AR Swanso. However, the court further held that such a place of residence has to be determined by finding out as to where the minor was ordinarily residing and where such residence would have continued, but for the recent removal of the minor to a different place. Skipping lordship, thereafter, where the minor actually resides at the time of application, may be some cases amount to rendering negatory all the provisions of the Act. In Shah Harishan Parse Ratnasan, 1975 Gujarat, the court held that legislative test of the court which has jurisdiction is the court where the minor ordinarily resides and not the court where the father resides and with whom the minor must be deemed to have been in constructive custody. Lordship. Thereafter, para 8 lordship.
When you took your son to Borpeta?
Since
22.
22 lordship.
When the guardianship application was filed?
Guardianship application was filed 22 lordship.
22 itself.
Lordship. Sixth of December 2022, guardianship case filed.
Okay.
My humble submission. But I also I am relaying lordship and my humble submission.
Yes. What you-
Yes, lordship.
No, how you explain this observation which you just now read?
Lordship.
That however, the court further held
Yes, lordship.
that such a place of residence has to be determined by finding out where the minor was ordinarily residing and where such residence would have continued but for recent removal of the minor to a different place.
Not removed, lordship, not removed, but I can prove only from their statement, lordship, and my school, my residence, and my son's school admission receipt, lordship. Lordship, page 11, paragraph 9. It is their statement, lordship, their government. That petitioner came to know that opposite party again married a person, namely Habibur Rahman, son of so-and-so, village Bhatnawati sir, in the district of Borpeta, Assam, through a marriage agreement. And since then, they have been living as husband or wife. It is not my statement, lordship. It's his statement.
Okay, yes.
Lordship. First, lordship, I will point out, lordship. My friend says that the marriage was dissolved. That dissolution, declaration, lordship, is page 15, lordship.
No, assuming that the marriage is illegal marriage.
Actually, not dissolved, lordship.
It is not dissolved.
Not dissolved, lordship.
And
That's why, lordship, I am pointed out this, lordship. If this thing is, lordship, going to happen in the society, lordship, it will be bad impact, lordship. She gave a declaration that I will live separately. All this must, lordship. That's why, lordship, I want to point out this, lordship. She want to live separately, lordship. She made their lordship. and she may reside with her parents' house, lordship. So, lordship, only lordship, by giving the declaration, lordship, she can, lordship, marry another person, lordship. That cannot, lordship, actually. That's why I pointed out, lordship.
No, but the question is not regarding her marriage, regarding where she is staying presently.
She is staying, but I am saying, lordship, that staying is illegal, lordship. Because, lordship, as of lordship, I am claiming that she is my wife, lordship. Then why she is staying with another person, lordship? That's all, lordship, I am disputing that address, lordship. She cannot use that person's address, lordship, as her address, as well as the address of my son, lordship. How can, lordship? Because if her marriage at all is not legal, lordship, then that address cannot be used by her, lordship. This is one point, lordship.
You also know that she is staying in Borpeta.
She residing, but I am saying that is illegal, lordship. That's why I am, lordship.
Marriage may be illegal.
Yes, lordship.
And
Illegal and unauthorized, lordship.
what is your submission regarding that your son is studying in a school in Borpeta?
My son, while, lordship, he was with me, lordship, then my son studied under my jurisdiction, lordship. That is, I have, lordship, I have given also received, lordship, here, lordship. She was residing here, lordship, and I given admission, lordship. That admission, lordship, that received as page, lordship, 36 division, lordship, no opposition, lordship. So residing under, lordship, Nogarbara area, lordship, Nogarbara. That is my under my area, lordship.
Page
36, lordship, in my period opposition, lordship. This is certificate, lordship, given by certified by the headmaster of the school, lordship, principal, lordship.
Which date?
A letter, lordship, and type copy is there, lordship. Type copy I have also, lordship, placed page 35, lordship, where the type is there, lordship. Certified that this is the counterfolio of admission receipt of Umar Farooq Zaman of class LKG, SD eligible 19/12/2022, principal HC PS Nogarbara, Assam. So, lordship, this receipt, lordship, while, lordship, he was admitted, lordship, in my area, lordship. And how she filled a, lordship, I drove my wife with my child, lordship, with the school, lordship. And there, lordship, she filled it from there, lordship. So, lordship, at that, lordship, I also lost an FIR, lordship. Immediately, lordship, I have lost an FIR, lordship. That may be seen page 33.
Okay, whether the question of jurisdiction was raised before the trial court?
No, that is not done, lordship.
Not raised by any party?
No, not.
Neither the court question about the question
What
of
was that
jurisdiction?
question, lordship, that I do not know, that I have not knowledge, lordship. So this is on fact, lordship. And now, lordship, even, lordship, if I go to the another aspect, lordship, the communicating, lordship, area, lordship. The Amingaon court is convenient for both of us, lordship. For her also, for me also, lordship. And Borpeta is inconvenient, lordship, because there is the Brahmaputra river is the, lordship. Only one boat communication, lordship, in a day, lordship. I mentioned in the petition, lordship. So, lordship, if a person go, lordship, then after completing the court work, lordship, she cannot or he cannot return to the home, lordship. There is also a fact, lordship. Now I am a school teacher, lordship. I cannot avoid my school duty, lordship. So, lordship, if I have to go, either I have to go on one day earlier, lordship, and then after, lordship, on the particular day, lordship, I have to complete the court, and there on the next day, lordship, I have to return back, lordship. Because river is there, lordship, and the boat communication, only one boat goes, lordship, at the 9 AM, and it return the evening at 3 PM, lordship. And thereafter, if the boat is missed, lordship, so thereafter no scope is to come, lordship. So, lordship, that communication, lordship, is inconvenient for both of us, lordship. There is one fact, lordship. And, lordship, it is another fact, lordship, it is a civil matter, lordship. She, lordship, kindly take this point, lordship. She, lordship, can clear from my house, lordship. Then she went to the Mongoldo, lordship. Then she arranged the notaries, lordship. I don't know how notaries passed, lordship, and even the notary, lordship, also have no power to, lordship, issue such type of dissolution of a marriage, lordship. Notary section 8, lordship, there is specifically says, lordship. And in that section, lordship, there is no any scope of dissolution of marriage by notary, lordship. But she took such a risk, lordship. She alone, lordship, she went to the Mongol Doi. She can do this all, lordship. But why lordship 2 days, 2-3 days lordship, he cannot come to the American court lordship. So lordship, actually lordship, only she is lordship harassing me lordship. In the one side lordship, she lordship deserted my life lordship. In another lordship, again she is lordship want to putting my some another burden lordship to lordship attack me the Barbara court lordship. And another fact lordship, her new husband lordship, he is lordship threatening me lordship. If lordship I go lordship, because of how she threatening lordship, I lordship took an interim order in the before the court below lordship. Now he says, I am just trying to meet my wife lordship once again by way of this interim order. That's all lordship, she is threatening my lordship through some other person lordship. If I will go there lordship, he may beat me lordship. So lordship, these are all issues of their lordship. She lordship deserted my life. Again lordship, just simply lordship, she cannot come to the American court lordship. Why I have to take to the Barpeta court lordship? Or her exemption may be given lordship that she is an ability, she may not come lordship, she need not to come. She can engage the her counsel lordship. So lordship, these are the point lordship. And lordship, if lordship goes lordship, I have also lordship one judgment lordship. In this point lordship, this Kolkata High Court lordship, it is lordship, this only similar type of case lordship. The Kolkata High Court lordship, with reference to some judgment of the Honorable Supreme Court said that the residence lordship only by virtue of a school receipt lordship. That is not the lordship address of ordinary residence of the child lordship. That is says lordship. There are also 3 issues or 3 receipts or there lordship, school receipt. The mother lordship, she left the husband house and she decided to another house lordship. And there is also, she gave the admission, 3 receipts are there lordship. The court says the 3 receipts she only purported or brought only to make the jurisdiction in their lordship. So lordship, this type of plea was rejected lordship by this court lordship and says the ordinary residence will be the residence of the husband or father. Thus lordship, this judgment will be taken of lordship.
You have reply also.
There is similar
Mr.
issue.
Das, you have any matter? Item number?
Item number 10, Lord, in this case. One thing, Lord, I would like to file a fresh, not fresh, recasted substantial point of law, Lord. Let the matter be listed on Monday.
Okay, heard Mr. A. Das Gupta, learned senior counsel for the appellant, assisted by Miss
Monday.
B. Das. On request of Ms. Das, Mr. Das Gupta, let this matter be listed on Monday is 23. 23rd.
I have formulated all these things, but I have to develop it.
Okay, on 23rd. Mr. Goswami, what?
Item number 6, Lord.
Because I intend to dictate it now. Then instead of keeping you waiting,
Any dealers?
item number 6. Both sides are there.
Same for the caveat one. Respondent.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. F. A. Laskar, learned counsel for the respondent. Due to paucity of time, this matter could not be taken up today. Let this matter be listed. When?
Any
After vacation.
after vacation.
After puja vacation on a date to be fixed by registry.
Listen, this is actually an admission method. It will be over in 5 days.
Only admission.
Only admission. I'm ready to deposit 50%. That kind of a year.
Okay, then Tuesday,
Yes, I'll take a bit.
on Tuesday. 24,
Wednesday, also.
Wednesday, 25.
Next Wednesday.
Yes, Ms. Sharma, any,
Lordship, my item 25 for orders, Lordship. So notice was issued, Lordship, but there is no office note. And one more prayer that, Lordship, this is a divorce decree, so the first date, no stay was granted, but I came to know from the client that he is looking for girls for second marriage, Lordship. So I'm praying for a stay also, Lordship.
no, how you can prevent him to marry again if there is
But
a divorce.
Lordship, my case will become infractious because she wants to continue her conjugal life,
Today we are not taking up.
Lordship.
We may fix a short date.
Lordship, registry may be directed to give a note what is the present position of service, Lordship.
Okay.
Because I
Third,
take
you have gone through the record.
yes, Lord. 6th of August, I take steps, and from 8th it was sent from the registrar.
Heard Miss B. Sharma, learned counsel for the petitioner. There appears to be no office note regarding the fate of notices issued to the respondent. The registry is directed to verify and put up a proper office note.
Next week, Lordship.
Stop. Let this case be listed.
25.
No fixed date. In the next week on a date to be fixed by registry.
Lordship, item number 36, hearing matter. The matter may come up after ensuing some puja vacation, your Lordship.
Both of you are there.
Yes, and my lord, in this case, my lord, respondent number 1, who was the claimant, my lord, he already died on 17/7/2023. So they have to take the step for substitution now.
You have to take.
I'll take the instruction.
Heard Mr.
H. Buraga.
H. Buraga had learned counsel for the appellant. Also heard Mr.
A.K.
A.K. Gupta appearing for respondent number 1, who submits that respondent number 1 has expired on
17/7/2023.
17/7/2023. Stop. In view of the submissions made by learned counsel for respondent number 1, the appellant may take appropriate steps in this regard. Let this matter be listed after puja vacation. Yes, now we can hear.
Lordship. Yes, Lordship.
Peacefully.
So, Lordship, the judgment is irrelevant, Lordship, here, Lordship. So my plea is that, Lordship, as I am the natural guardian, Lordship, and the child, Lordship, also took birth in my house, Lordship.
Who is natural guardian?
I am, Lordship, I am father. So the child also took birth at my house, Lordship, and whatever, Lordship, his Lordship done later on, Lordship, that is unauthorized, Lordship. And that child also, Lordship, took admission. I also gave admission, Lordship, in my under my area, Lordship. His Lordship, without transferring, Lordship, from that school, Lordship, she cannot take the Lordship admission to give admission, Lordship, in other school, Lordship. Lordship, I am father, Lordship, at least my consent or my something was there, Lordship. That is necessary, Lordship. And school transfer is also not taken, Lordship. So, Lordship, that admission is also still there, Lordship, in my under my area, Lordship. So in such a situation, Lordship, I am saying, Lordship, as I am a father, Lordship, my address, Lordship, would be the OD residence, Lordship. And the address of her alleged, Lordship, so-called new husband, Lordship, that cannot be the OD residence, Lordship. That is the child, Lordship, has taken under him, Lordship, it is unauthorized, Lordship. That person, Lordship, he is no way related to my son, Lordship. She may be the wife of that person, but that person is not the father of my child, Lordship.
But she is the mother of the child.
Mother is there, Lordship, but now she is, Lordship. Now, as I know, later I came to know.
What cases you are relying?
Yes, Lordship, that I have judgment, the Dilena judgment. There was similar type of issues was there, Lordship. Some paras are important, Lordship, but I have to read, Lordship, some of the paragraph, Lordship.
You come to the relevant provision.
Yes, Lordship. There is also many, several paragraphs are relevant, Lordship. There are also even then, Lordship, I am reading, Lordship, paragraph 22, Lordship. That will be in paragraph 21, Lordship. Some of the Supreme Court cases are referred, Lordship. Quoted here, the quotation is there, Lordship. And 22, Lordship, the court, Honorable Court, Lordship, the given the clarification. A close reading of the observation of the division bench of Kerala High Court. Lordship, from I have to, I can skip something, Lordship. Thereafter, Lordship, after 3-4 lines, the expression, the place where the minor ordinary resides, Lordship. For I can start, Lordship.
Yes.
Yes, Lordship. The expression, the place where the minor ordinary resides, in my opinion, means the place where the minor generally resides and would be expected to reside, but for a special circumstances, I am not unmindful to note. Rather, I am in agreement with the learned senior counsel on behalf of the petitioner that in case of marital dispute between the husband and wife, paternal home of the wife is the place where she can take paternal home lordship. She is not residing at the paternal home lordship shelter as she leaves her matrimonial home with her minor child. The mother residence should be considered as the ordinary residence, of the minor. However, in such a case, intention of the mother is required to be looked into from the factual background of each and every case. Here, lordship, my factual background, lordship, I have not dropped her, lordship. She willingly freed up from lordship. So that fact also, lordship, kindly note into lordship.
She is not happy with you.
So why
Yes.
she not, then why she did not raise any voice, lordship, before the police, lordship, that I am torturing her or I have done anything, lordship. She never done anything, lordship, never raised such voice, lordship. Suddenly she pleaded, lordship, without informing anything, lordship, anybody, lordship. At least she can, lordship, raise the plea before the villager, lordship. She can raise before his parents also, lordship. Now, lordship, she is even not in a position to go to her parents' house, lordship, because her parents also dislike her, lordship, because of her conduct, lordship. Society also dislike her, lordship, because a husband, let us say teacher husband, lordship, not a backup person, lordship. He is a teacher. Even then, she, lordship, left her, lordship, left him, lordship. In the lordship letter, lordship, I can skip also some line, lordship. Again, lordship, well settled, lordship. After lordship, again 5-6 lines, lordship. Well settled is law, lordship. That maybe take, lordship.
Yes.
Well settled is law that if a child is removed to a place, the place of such removal will be ignored for the purpose of determining the jurisdiction. If removed, lordship, then lordship, that place can be removed, lordship. That place cannot be jurisdiction, lordship, of the court to entertain the application, and in spite of such removal, the minor will be deemed to have her residence at the place where he or she was ordinarily residing, and the new place to which the minor may have gone to or may have been removed will become the place of ordinary residence of the minor only after the minor has settled down at that place for a reasonably long period. There must be, lordship, some long period. If the child already settled there, lordship, for a long period, then can be, lordship, then also can be, lordship. And here, lordship, immediately, lordship, I filed the guardianship petition, lordship. So residence that passed by the test of casual temporary residence. So, lordship, again, paragraph 23 says, lordship, in the instant case the minor was born at Kolkata, she used to stay at Kolkata till the last week of December 2018. She was admitted at last so-and-so school, that is Kolkata, lordship. She continued her study in the school till December 2018. After the petitioner had left the matrimonial home with the minor, she took shelter in a flat at South City Residency, Prince so-and-so, Kolkata. Till that, the petitioner did not take any formal application for transfer of her minor child from so-and-so school. This court is not in a position to rely upon two money received purportedly issued by one so-and-so school, that is the mother's new residence, lordship, and same so-and-so school. In money receipt issued by the school so-and-so, even the name of the minor and date of admission are not mentioned. Therefore, this court has every reason to hold that these documents were created for the purpose of creating jurisdiction of the court at Birham. Since the minor was ordinarily residing at Kolkata since her birth, and she was pursuing her studies in a primary school at Kolkata, I cannot but to hold that the minor's ordinary residence place of residence is within the jurisdiction of the landed district judge, South 24 Parganas of Alipur. There is the father's place, lordship. In view of that has been stated above, I do not find any illegality or material irregularity in the impugned order, that is so and so. And thereafter, lordship, paragraph 24 says, Thereafter, the instant revision petition so and so is accordingly dismissed on contest. So in such a situation, Lordship, the situation is exactly same, Lordship. In that case also, Lordship, the mother, Lordship, she brought some receipt to show that she is residing under that jurisdiction. But Honorable Court says that no, that cannot be, because that is only brought, Lordship, to show the jurisdiction of the court. And vital point is that whether I remove them or they intentionally left my house, Lordship. If I remove, then Lordship, my residence, Lordship, to some extent, Lordship, would not come, Lordship. But I did not remove, Lordship. She pleaded away. And she pleaded, Lordship, even, Lordship, without divorcing me, Lordship. Now she is residing with another boy, Lordship. And that residence, Lordship, my humble submission, Lordship. that
Okay,
cannot be-
you have made your submission.
Yes, Lordship.
Any reply?
Lordship. My
Brief reply.
just 2 points, Lordship. That my learned friend, whatever submit is not tenable in the eye of law, Lordship. Lordship, my friend submitted that he has filed FIR against the incident. Lordship may peruse page 33 of his affidavit in opposition.
Yes.
Lordship, Officers Nagarpura Police Station, subject application for inquiry regarding missing, Lordship. Regarding missing, he informed the police officer regarding my missing.
Yes, at that time, I found her missing, Lordship. That's why. Why not? When, Lordship, I drove her to the school, Lordship, then after, Lordship, I am also employee, Lordship. When I in the
Lordship,
university, I came
I am
to my house,
submitting later.
I found that
Complete his
she is not there,
submission.
Lordship. That's why I'm saying
Submitted.
missing. Yes. No, you submit. I'm missing. Why you said it is the wrong? Missing is the actually missing there.
So no FIR was lost against me, and I have admitted that yes, I fled away. No controversy is there. I fled away willingly. Lordship, my learned friend also submitted that admission receipt is not the genuine record of the to prove the ordinary residence, Lordship. Yes. I divorced the admission receipt. Then, Lordship, page 11, para 9, whatever I have submitted earlier, that his statement that I am residing with my remarried husband, new husband, that is admitted position, admitted, Lordship.
Page 11, para 9.
Para 9, Lordship.
Page?
Page 11 of my transfer petition. Lordship got it?
Yes.
Para 9. Basis later on, the petitioner came to know that the opposite party again married a person, namely so-and-so, son of so-and-so, resident of village so-and-so, in the district of Borpeta, Assam, through a marriage agreement, admitted position.
What is this application?
Lordship,
What this is the application filed by
filed by the respondent in the guardianship case, Lordship. Lordship, then my learned friend also submitted that Guwahati is more convenient place. Lordship, he is also serving in the district of Borpeta, Lordship. Lordship may peruse page 10, Lordship.
Yes.
Paragraph 4. That the petitioner is a primary school teacher by profession. Lordship got it. And he has been working as headmaster at 959 number KD Digi LP school under Senga block in the district of Borpeta, Assam. And the guardianship case has been filed here only to harass me, Lordship, nothing else. So my humble submission before you, Lordship, is that my learned friend whatever submitted is beyond law, beyond jurisdiction. So the submission whatever he made is not tenable in the eye of law. and my transfer petition is maybe allowed. This is my humble submission before your lordship.
We heard Mr. S. H. Rahman, learned counsel for the petitioner. Also heard Mr. S. Hawk,
Yes, Lordship.
learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure, 1908, read with section 151 of the code, said code, has been filed by the petitioner, namely Srimati Usma Sultana, for transferring of the Miss Guardianship case number 03/2022 from the Court of Learned District Judge Kamrup at Amingaon to the Court of Learned District Judge at Borpeta. The facts relevant for consideration of the instant transfer petition, in brief, are as follows. Dash. Number one, that the petitioner and respondent were married to each other on 24/7/2016 as per Islamic rites and rituals. Stop. After the said wedlock, a male child was born on 4/5/2018, who has been named as Master Omar Farooq Zaman, and who was about 5 years old at the time of filing this transfer application. Stop. It is submitted by Mr. S. H. Rahman, learned counsel. Next para. It is submitted by Mr. S. H. Rahman, learned counsel for the petitioner that after about 4.5 years of the marriage, the respondent and his family members started torturing the petitioner, and there arose matrimonial differences between both the parties, and it became impossible for the petitioner to continue her conjugal life with the respondent. Stop. As a result of aforesaid circumstances, the petitioner left the house of respondent in the month of May 2022. Along with her child. And was staying at her parents' house. Where your parent house?
In the district of Borpeta also.
In the district of Borpeta. So it is also submitted by learned counsel for the petitioner that the petitioner ultimately decided to dissolve her marriage with the respondent. And accordingly, she made a declaration to that effect before notary, Dorong, Mongoldoy on 26/7/2022. And the respondent was informed about the same by sending a copy of said declaration to him. Stop. It is also submitted by learned counsel for the petitioner that thereafter the petitioner married one Habibur Rahman, son of Samsul Haq, who is the resident of village Bhatna Paiti Char under Alopati police station in the district of Borpeta on 12/9/2022 by executing a marriage agreement on the said date. Stop. It is further submitted by learned counsel for the petitioner that after her marriage with the said Habibur Rahman, the petitioner started living as his wife along with her minor child in the house of said Habibur Rahman at village Bhatna Paiti, Bhatnapaiti, Bhatna Paiti Chor, under Alopati police station in the district of Borpeta. Stop. It is also submitted by learned counsel for the petitioner that the son of the petitioner, namely Master Farooq Omar Zaman, who was also staying with her, was admitted in Ankur class, Ankur within inverted comma, at Nava Noor Jatiya Vidyalaya, Bhatna Paiti Chor on 1/11/2022. You are pregnant.
Lordship.
Now you are pregnant.
Of Lordship, subsequently, I
you
have
have-
delivery already been held, and marriage also registered before the Qazi.
No, now you have one more children,
One
more
more
child,
children, Lordship.
son or daughter.
Daughter, Lordship.
How
Page-
old?
Page
How,
48.
how old she is?
Just newborn, Lordship, 6/8/23, date of
Six.
birth.
Learned counsel for the petitioner has submitted that the petitioner has delivered a girl child on 6/8/23 from your new husband,
Lordship.
from her new husband. And she has been advised not to. No. Yeah, she has been advised to cut it off. Stop. Learned counsel for the petitioner has submitted that in the meanwhile, the respondent has filed an case, filed an application under section 9 and 12 of the Guardians and Wards Act 1890 in the Court of Learned District Judge Kamrup Amingao, seeking custody of her minor child, Master Omar Farooq Zaman. The said guardianship case has been registered as registered as guardianship case number 3/2022. Stop. It is also submitted by learned counsel for the petitioner that in connection with the said guardianship case, a miss case being Miss J case number 5/2023 was also registered, wherein order was passed, wherein an interim order was passed against the present petitioner to bring the minor child at Atal Udyan Adabari, Guwahati, to meet the respondent on each and every Sunday.
Every first Sunday of every month, Lordship.
On first Sunday of every month. Stop. Learned counsel for the petitioner has submitted that the court of Learned District Judge Amingao, District Judge Kamrup, Amingao, does not have jurisdiction to entertain the application under section 9 and 12 of the guardians. And what is section 9? Section 9 of the Guardianship and Wards Act 1890 as stop. It is submitted that the court which would have jurisdiction to entertain such an application would be a court which would be a court having jurisdiction in the place where the minor ordinarily resides. However, he submits that in the instant case, the minor Master Omar Farooq is residing with his mother, that is the petitioner, in the residence of the husband of the petitioner, namely Habibur Rahman, since after the marriage of petitioner with Habibur Rahman. Stop. He also submits that the fact that the minor Master Omar Farooq Zaman is the ordinary resident of Bhatnai Paiti Chor in the district of Borpeta would also be revealed from the fact that he is a student of class within inverted comma Ankur in Nava Noor Jatiya Vidyalaya at Bhatnai Pati Chor. And in support of the said submission, learned counsel for the petitioner has also annexed a copy of admission receipt dated 1/11/2022 issued by the school as annexure 5 to his petition. Learned counsel for the petitioner has also submitted that even in the application filed by the respondent under under section 9 and 12 of the Guardians and Wards Act, 1890, before the court of London District Judge Kamrup at Amingao, the respondent has disclosed and admitted the fact that the petitioner is now living as wife of one Habibur Rahman in Bhatnaipati Char in the district of Barpeta. Stop. Learned counsel for the petitioner has submitted that as it is apparent from the facts revealed from the materials on record that the minor whose guardianship is sought for in the misguardianship case number 3/2022 is an ordinary resident of Barpeta district, and hence he submits that the court of district judge at Amingao does not have the jurisdiction to try to entertain the application filed by the respondent. Stop. The petitioner also submits that the learned counsel for the petitioner also submits that the respondent himself is a teacher, is a primary school teacher at 959 primary school teacher and presently working as headmaster at 959 number Kedighi, Kedighi, Kedighi LP School under Chenga block in the district of Barpeta. However, in spite of that, he had filed the guardianship application in the court of district judge Kamrup at Amingao only to harass the present petitioner. Any other point from your side, which I have not dictated?
Submission made by my friend is beyond record and no locus without challenging the merits, etc. Dissolution of marriage. He has no locus to
submit before this on our floor.
Learned counsel for the petitioner has also submitted that the petitioner is not denying the fact that she has left the respondent and has married Habibur Rahman. However, he submits that said marriage has not been challenged by the respondent. Stop. He also submits that even if the marriage of marriage of the petitioner with Habibur Rahman is questioned, the fact that her son is staying with her in the residence of Habibur Rahman and is a student of a school that is which school? Named student of a school, namely
Navanur Jatiya Vidyalaya.
Nobonur Jatiya Vidyalaya, Bhatna Paiti Chor, since last 2 years. Hence, it is submitted that the court of District Judge Kamrup Amingao does not have jurisdiction to entertain the application filed by the respondent. And he also submits that for the said reasons, the misguardianship case number 3 of 22 may be transferred to the court of Learned District Judge Borpeta, which is the jurisdictional court to entertain any such petition regarding guardianship of her minor son, Master Omar Farooq Zaman. Stop. On the other hand, Mr.
Yes, of course.
S. of Learned Counsel for the petitioner, Learned Counsel for the respondent has submitted that the petition filed by the petitioner for transfer of the misguardianship case number 3/2022 from the Court of Learned District Judge Kamrup to the Court of Learned Session Judge and the District Judge Borpeta is not maintainable. Learned Counsel for the respondent has submitted that before that his son Master Omar Farooq Zaman was born on 4/5/2018. Where was at Where you were born, the birth certificate is page 32, come to page 32.
Yes, Lordship.
Page 32, the place of Simnitola.
It is
or
Bhokora, dear Lordship.
Huh?
Yes, Bhokora, dear Lordship.
Place?
Bhokora, the
No,
BACKSURADI.
that is the address of,
Other Lordship, at that time, Lordship, it is my address, Lordship.
where is Bhokuradia?
Oh, page 32, Lordship, birth certificate, Lordship, birth certificate, Lordship. Address of the parents. Address of parents of the.
No, this place of birth is Simnitola.
Oh, it
MPHC.
State dispensary.
Oh, it a hospital.
Simnitola.
Shimlitola.
Simli.
Shimli, SIMLI.
At Simlitola MPHC in the district of Kamrup.
No, district Golpra. Shimlitola is under district Golpra.
Name hospital, Lordship. Address is Lordship, Kamrup district, Lordship.
Oh, Simlitola is in Golpara district. Simlitola, when in the district of Golpara, and after his birth, he was residing in the residence of
Yeah, Bhokura, dear
the
Lordship.
respondent at village Bhokuradia, BHAKHURADIA, Bhokuradia, under Nagorbera police station in the district of Kamrup, along with her mother, that is the petitioner. Stop. Learned counsel for the petitioner has also submitted that on, where is the missing entry?
Missing entry, Lordship, page 33.
That on that on 13/9/2022, when the no, that on 12/9/2022, the respondent after coming back to his residence from his school did not find his wife, the petitioner, and his son in the house. And thereafter, on the next day, that is 13/9/2022, he filed an application regarding missing of his wife and son, who was aged about 4 years, 3 months at that time, before the officer in charge of Nagarbera police station. Learned counsel for the respondent has submitted that
Sorry to interrupt, Lordship. The missing report before the officer in charge is neither registered nor received.
no, I'm mentioning his submission.
Sorry,
sir.
Lordship. Sorry, Lordship.
No, you can interfere. Therefore, I'm dictating here. You, both of you sit down. If any where you find that something has to be added regarding your submissions, you may intervene. He has made this submission, therefore I'm dictating. What was the last name? Submitted that his son was also admitted in LKG class at Holy Child Public School at Nagarbera when he was residing with the respondent. And in support of his submission, he has annexed a money receipt issued by the school authority staff. Learned counsel for the petitioner has, learned counsel for the respondent has also submitted that the petitioner has made false accusations against the respondent in her transfer application, as she was never subjected to any cruelty or never harassed by the respondent when she resided with her in his residence at Nagarbera. Learned counsel for the respondent has also submitted that the petitioner married for the second time to one Habibur Rahman without lawfully dissolving her marriage with the respondent. It's that a notary does not have a power to dissolve any marriage under law. And the petitioner did not take lawful recourse to dissolve her marriage with the respondent before entering into the second marriage with Habibur Rahman. So he therefore submits that the marriage of the petitioner with Habibur Rahman is illegal marriage, and hence the address of Habibur Rahman cannot be shown as the address for the petitioner herself, or to show that her child from the first marriage, that is Master Farooq Rahman, Farooq Omar Zaman, is the ordinary resident of the place where the residence of Habibur Rahman is situated. I'll stop here. I'll keep it part heard. And continue dictating again in the court on some other day.
Lordship may pass order.
No, at least that your submission part.
Yes, Lordship.
My part I may dictate in chamber, but your submission part. So I'm fixing it part heard and keeping it on third or second. You have to be there because his part is over. When suggested it.
It tell Lordship, as per our convenient Lordship, I have no issue, Lordship.
You have to remain there at 4 p.m.
4 p.m. Lordship. On when Lordship date?
Therefore choose a date.
Day after tomorrow or tomorrow, lordship, you can fix any day. Or any day, lordship, I don't.
Let him type out. We will. एक अलग से order लिखना. Heard. Mr. S. H. Rahman, learned counsel for the petitioner. Also heard Mr. S. Hawk, learned counsel for the respondent. The hearing remained part heard. Let this matter be listed again as part heard matter on on 27/9.
57.
27/9. Any date you suggested?
4 PM, Lordship.
3:30 PM. You may choose a date, other date. 39.
26, Lordship, or
Right.
30.
The 30 only except 30 lordship.
Huh?
Except 30 lordship. 30 I have no problem, lordship.
Let it be first
1st of October.
of
Yes,
October.
Lordship.
Because
Yes, Lordship.
your case has not been cited. Have I mentioned about the case which has been cited by you? Case citation, Hassan? You point out on the next date.
Lordship.
Huh? At 3:30 PM. ये तो record to Abhishek of the Mullavad Khatib.
Lordship, 1st of October.